Can you elaborate? In what sense was consensus not reached?
Yeah, maybe I should allow Advocate Tifo to, because we had a brief discussion about that this morning, and Advocate Tifo indicated that his instructions have now changed, my lord.
Yes.
Good morning, Your Lordship.
Morning.
Your Lordship, we don't want to delay the court. With due respect, I request the court to allow my counsel to address on certain issues that transpired yesterday.
Yes.
Because, my lord, we have realized yesterday that counsel for accused number 5, after the state presented 2 letters, she did deal with the letters. She read the letters on record, and she was happy with the letters. And my counsel was not allowed to deal with those issues of the letters. The application that is pending from advocate of number 5 and my counsel, they might be dealing at a certain point with the letters, but we were instructed to reply on the letters yesterday, but we could not. Therefore, I humbly request the court to allow my counsel to deal with those issues, and also the new instructions that came up, my lord. As a court, this is.
Yes.
Thank you.
Yes, please, the court, Your Lordship. My response, Your Lordship, is in relation to the allegation that I was the only one who had the 375 dockets, and whereby it was allegedly given to me on the 23rd of March 2022 at the office of Advocate Waloi. I can confirm that it's true. On the 23rd of March 2022, I was at the office of Advocate Waloi for the matters of the pre-trial conference. And we were with Lieutenant Colonel Buthelezi, one of the investigating officer of 375-01-2019. Together, we were with both of them. Lieutenant Colonel Buthelezi and Warrant Officer Mishak Makubu. Warrant Officer Makubu is the one who opened the case 375. And the case 375 is a state as per Warrant Officer Makubu. And amongst the offenses alleged, it's the defeating the ends of justice, accessory after the fact, conspiracy to murder. In relation to the same incident that happened at 13511 Kutanon Street, Nuzama section in Phosphorus. And this will be for the first time that the court will hear this, that case 636 was also opened as per state. It was the state as per Constable Matebula of
It was
For-
also opened. I didn't hear what you said subsequently.
the 636
Yes.
is the docket open as per state by Constable T. Matebula of Phosphorus Police Station. And amongst the
Did you
offenses,
say warrant officer Matebula? Warrant
Constable,
I didn't hear you well.
Constable T. Matebula. On the 26th of October 2014. And amongst the offenses alleged, or the crime committed, alleged to have committed, it's a robbery with aggravating circumstances, which resulted with a murder, and the firearm was used. Docket 636, 10/2014, Your Lordship, was opened at Botshilong Hospital. After Constable Matebula and his colleague, as they were the first officers on the scene, they were called by 1011 that there has been a shooting happened at 13511 Kutanon Street, Mzamo section. When they arrived there, they were informed that the victim, being Senzo Meyiwa, has been taken to hospital with his vehicle driven by Nontanta Kilukumalo. And the police officers, Your Lordship, on arrival at the Botshilong Hospital, they were taken to the ward or the room where the body of the deceased was. And at that time, the disease was confirmed or was declared dead. That's where, Your Lordship, the police, as they are called, it was confirmed to them that the disease was died as a result of the gunshot.
Can I be clear, as you will continue just shortly? Are you giving evidence?
I'm not giving evidence, Your Lordship. I am laying the basis in terms of these two dockets. And then I'm going to the letters. So I just want to lay the
I just
history.
needed clarity.
Yes.
Yes?
Okay. Yes. So, having said what I said in relation to these two dockets, Your Lordship, is that,
No,
as
no,
I said,
you were still telling me that they were taken to a room where the
Yes.
body of the deceased was.
that's correct. You have to confirm.
Sorry if I distracted you, but that's
Okay.
where you were.
Yes, that's, yeah. they confirmed, as they were advised or told by the medical practitioner, that they see for themselves as the police to be convinced. And that's when the case was opened. So, based on the circumstances upon which the case has been opened of 636, it then became inquest.
I didn't hear you. Are you saying an inquest docket was opened, or are you saying, given the background, an inquest docket should have been opened?
I said the inquest was open. The origin of 636, it became an inquest because it was opened by the police on behalf of
Was
the
it
state.
allocated a number, an inquest number?
At the same time, it was allocated the case number, the case number.
No. You are talking of an inquest. Surely it must have an inquest number.
Normally it does, yeah. But initially, from the, let me say, Your Lordship, the history of 636, as I've been told, it has been investigated by more than 70 investigating officers.
No. You are now on another point. I will welcome that in due time. The question I have for you is whether an inquest number was allocated. Because in the final analysis, all these documents you are talking about may have to be looked at.
Yes.
Now you have mentioned an inquest number. As far as I know, an inquest number, an inquest should be, an inquest docket should be opened as per a register which allocates numbers, just like dockets.
That's correct.
When we say CAS, it means they were opening a case and they looked at the last number. When it came, they gave it the subsequent number and said CAS 363. But then now, in the inquest docket you are talking about, my question is the number allocated to it, so that when somebody needs to look into that, they will then have to look at the inquest number. They may, whoever will do it may have to even look at the inquest register related to that police station, so that the matter can be looked at deeply.
Okay. Your Lordship, point taken. However, for the purpose of progress, Your Lordship, let me not base too much at the history. For the purpose of progress, let me confine myself to the case number and the offenses stated here, which was the robbery with the aggravating circumstances and the murder whereby a firearm was used. And for purpose of this, as I said, Your Lordship, is just to give the basis. As for if we need to know anything or the reason for the existence of phosphorus CAS 375-01-2019, the relevant source of information, it will be Warrant Officer Makubo from the Hawks. And the basis of the history in terms
To
of
avoid another misconception, you are saying the source will
the
be
complainant, I mean to say complainant.
the complainant
Yeah.
will be Warrant Officer Makubu.
In 375.
Are you mentioning him because you intend to call him, or what are you saying? Because if you say the source, it doesn't mean the court will go out and call Warrant Officer Makubu.
Warrant Officer Makubu is a complainant in 375-01-2019. And then I can remind this court back, it's on record that when I handed in Exhibit C and D, I was asked if I'm gonna call Warrant Officer Makubu and Lieutenant Colonel Buthelezi. I said, if need be, yes, I will. We are on record, Your Lordship, that these are my these will be the witnesses of 1 to 4. And then 636 complainant is also as per state Constable Matebula of Phosphorus Police Station. Then I'm going to the 2 letters. But however, Your Lordship, before I go to the 2 letters, further also as a point of clarity before this honorable court and for anyone amongst the councils here, the defense and the state, and but I will be saying this under correction. Let's Advocate Baloyi confirms this. At the moment, we learn to understand that case 636 is now having the different investigating officers, whereby the leading investigating officer is one Brigadier Kininda, and it's got the team of juniors that is investigating with. And warrant officer, Brigadier Kininda, in relation to 636, as a leading investigating officer, has deposed affidavits, 2 affidavits, insofar as his investigation or the findings of his investigations are concerned. And I will later ask the Honorable Court to read the affidavits of Brigadier Kininda for the record, after I would have dealt with 2 letters of the 2 letters purported to be from the DPP Johannesburg, Mr. Chauke.
My Lord, before
And-
you go to the letters, can I? Before you go to the letters, can I?
Can I check
Yes.
the proceedings yesterday? Were they interpreted to?
No, they weren't, but I do have my.
They were not.
No, because of time, we didn't, my Lord.
Oh, yeah, because I had said you can do it even before court starts.
Okay. Oh, no, I didn't get that, my Lord. I'm sorry. But sorry,
I
my Lord.
labored under the impression that what was stated yesterday was interpreted. Advocate Mshololo did raise a concern that a lot was said without being interpreted.
Yes,
My apologies, my
So
Lord.
when you came, I thought it's because you know that everything has been cleared, because interpretation doesn't necessarily have to be within the proceedings unless there is a reason why we want to do it whilst the proceedings are on. So if he hasn't as yet, I think the best is to deal with that and get it out of the way, because now something else is coming before the deliberations yesterday are interpreted to the accused.
My Lord, if I can assist the court, even yesterday, I think when we adjourned after 12, I requested the gentleman from Correctional Services for some time. They allowed me that time when something was not interpreted. So I can carry on with this, and then I can ask them again, because yesterday's was quite a lot, my Lord. I don't want to delay the court.
Advocate Mchololo, you raised the issue of interpretation.
My Lord, I think right now is the correct time that interpretation be done and during the proceedings so that they'll be able to follow the proceedings, my Lord. It doesn't serve any purpose if it's done after the court, as the court pleases, my Lord.
There you are. There you are. I think we need to start from yesterday because
It's not, no
it
problem.
doesn't make sense to pile something on top of something that they did not understand. I thought that has already been done. So I think we advocate, therefore we'll have to allow interpretation to happen before we add what you are coming with.
Okay. Can I sit down?
Yes.
And then can I, as you'll be interpreting, can I also be opportune moment, just within 2 minutes,
To, or you want an adjournment?
the nature? No, you can proceed. You can proceed, but I'll go and come back. My attorney is here.
Okay.
Sizoqala ke kuloko ebekuhloko izolo ke emuva kokuthi sesibuyile ke emva kwe lunch beku advocate Tefo ebedlulisela inkulumo zakhe enkantolo mayelana nodaba ebeludingidwa ke izolo. Uthe uma eqala ke ebhekisa kuyona inkantolo wayitshela ke inkantolo ukuthi akaboni ukuthi ubulungiswa buzokwenzeka. Kwakushoko nokuthi ke uma ngaba kuqhubeka ke ngendlela bekwenzeka ngayo izolo ke lokho kuzophoqa ukuthi nanjengoba etsheliwe abamangalelwa abamele ukuthi ke ayicele ke inkantolo ukuthi ke ingabe saqhubeka uma ngabe akashongo ukuthi akwenzeke lokho. Nanjengoba futhi ke yena ke ummeli wabo umangalelwa woqala ukuyofica kowesine. Futhi ke esho nokuthi ke ngendlela ke abone ngayo izolo engaboni ukuthi inkantolo imnikezile inhlonipho ayifanele ngoba bekufanele ukuthi yena ke abe nodaba aludlulisayo enkantolo ngokumayela nabamangalelwa abamele. Futhi ke etshela lenkantolo ukuthi befisa noma bekuyisifiso sakhe nanjengommeli wabamangalelwa ukuthi ke azwakalise ukuthi yena ke nabamangalelwa abamele abavumelani nesicelo senziwayo uyena ummeli kamangalelwa wesihlanu ukuthi icala lihlehliswe. Futhi ke kungasibona ke esho nokuthi ngasibona ke ubulungiswa noma ngazona ke imfuno zakhe umangalelwa noma ezobulungiswa zabamangalelwa abamele uma ngaba icala lingakwazi ukuthi lingaqhubeka ngoba lokho kuzabe kulibazisa bona ke. Ekusho futhi nokuthi ke umangalelwa wokuqala kanye nowesibili bona ke baboshwa bengaphandle kungafani nomangalelwa wesithathu kanye nowesine bona ke ababoshwa bephakathi eitoxin. Futhi ke ngokindlela ayitshele ngayo ke inkantolo la inkantolo ke iye inemibuzo kuyena ke ukuthi yena ke bekufanele ukuthi inkathi icala lihlehliswa ke inkathi bevela ke eBoksburg okokuqala kwakufanele ukuthi umangalelwa wokuqala nowesibili baphindile bakhishwa ke inkantolo ingabagcini ngaphakathi eitoxin. Futhi ke wanalo ke nedocument akhuluma ngalo ke elasayindwa nge-9 noma ke isinqumo esathathwa kwasayindwa nge-9 zika February 2020. Langa lelo ke yena ke athe uma ngabe ebheka ke wathola ukuthi kwakuyilanga kwakungesonto futhi ke engabaza nokuthi ke ukhona ke umuntu ongasayinda iphepha ke lasemsebenzini ngesikhathi ebekufanele ukuthi ngaso usendlini. Esithi ke nalowo ke yena ke umama uShamila ophethe ke abeshushisi uma ngabe kuphoqeleka ke ngafanele ukuthi abizwe eze khona lana azophendula ngalo ke lelo document lelo. Futhi ke nge-27 zika October 2020 inkathi noma isikhathi sokuqala bevela ke enkantolo eBoksburg abamangalelwa kodwa ke 26 ku-October 2020 nkathi-ke owengamele amaphoyisa uBhekiceleke wayenemhlangano-ke kanye ney'ntatheli la achaza khona-ke ukuthi amaphoyisa-ke sebekhona-ke abantu ababoshiwe beboshele lona icala lakhe uSenzo Meyiwa esithi lokho kwenzeka-ke kwiyinyanga ezishagalolunye ngaphambilini kokuthi abamangalelwa babe bayaboshwa. Meseqhubeka-ke inkantolo ibese-ke inikeza-ke inkantolo uvo-ke ngokuthi-ke ngakho konke lokho obekushiwo noma kukhulunywa uyena u-advocate uTifo izolo-ke yathi-ke izolo kusasa-ke yena-ke u-advocate uTifo uzamile-ke ngakho konke ukuthi enze ngendlela yakhe-ke ukuthi le nkantolo imlalele, kodwa-ke inkantolo ayikwenzanga lokho ngokuthi ingalandeli lokhu yena-ke u-advocate ebezama ukuthi-ke inkantolo noma azama ukuthi ayikhulumise ngakho. Futhi-ke okunye akukhulumile yena-ke ukuthi yindlela ekufanele ukuthi abantu abasebenza inkantolo bayiphathe ngakhona noma benze ngakhona-ke, kodwa-ke yona inkantolo yabe isibona-ke ukuthi emuva kokuthi inkantolo imtshelile-ke ukuthi u-advocate Tifo lokhu akushoyo ayihambisani nako, kodwa yena-ke bese nje ebuyela kulokho inkantolo ibisiqedile. Kodwa ngokwazi kwayo inkantolo akumele ukuthi kunjalo, uma ngabe inkantolo ithathe isinqumo kufanele ukuthi kundlulelwa ngaphambili-ke. Okunye futhi akhulume ngako inhlonipho futhi-ke kodwa-ke ngendlela inkantolo ebona ngayo ukuthi-ke yena-ke leyo nhlonipho leyo akayibuyiseli-ke. Inkantolo yasho nokuthi-ke nanjengoba ihlezi khona kule ndawo ihlezi kuyona-ke nayo-ke ayisho ukuthi akangeke angawenzi amaphutha, kodwa-ke kunendlela-ke ngokomthetho ekufanele ukuthi izinto zichazwe noma zenziwa ngayo khona la enkantolo. Ngoba inkantolo ithe mayiseqhubeka-ke yathi u-advocate uMshololo kukhona lokhu ebengidlulisa enkantolo. Mase kufika isikhathi sakhe-ke ukuthi yena-ke uma inkantolo isimnikeza ithuba uzokusho lokhu akufanele akusho, angathathi isikhathi somunye umuntu noma isika-advocate Mshololo akushe ngakho. Futhi-ke okunye inkantolo ekuchazile-ke ukuthi u-advocate Tifo ushilo inkantolo ukuthi akenzi noma akalethi eyakhe imithetho-ke, kodwa-ke yathi inkantolo-ke kodwa layo imithetho leyo kusafanele ukuthi ihambe encwadini yoyibheka ibone ukuthi ikhona na, ngoba-ke imithetho yasenkantolo ibhaliwe phansi futhi kunendlela umuntu akufanele ukuthi enze ngayo uma ngabe esenkantolo. Futhi-ke uletha izinto-ke ezingakhange noma ezingazange zikhulunywe uyena u-advocate Baloyi kanye nayo u-advocate Mshololo. Ngamanye amagama-ke uletha izinto ezintsha-ke inkantolo engazi ngazo. Yabe seyimtshela-ke ukuthi u-advocate Mshololo akucelayo nje ucela isikhathi sokuthi-ke ayilungiselele emuva kokuthi-ke ethe wathola lelo dokodo elisha ebekade engalazi. Dokodo lolo-ke umthoshisi atshilo ukuthi nge-23 zikaMarch 20 kuwona lo nyaka lona-ke lathola u-advocate Tifo kuphela, kodwa bebabili abameli abakhona kuleli cala leli. Ngalokho-ke inkantolo-ke iyimisele-ke ukuthi imnikeze isikhathi esanele yena-ke u-advocate Mshololo ukuthi ayilungiselele. Kunye futhi-ke inkantolo echazile-ke ebekhulunywa uyena u-advocate Tifo ukuthi eshilo ukuthi-ke ungqongqosho-ke ungqongqoshe akazange asayina, kodwa kwaba uyena u-advocate Shamila Batoyi owasayina. Uma ngabe-ke uyena-ke owasayina, lokho kusho ukuthi-ke wakwenza lokho kuyisonto-ke, futhi yilokho bese kushilo ngaphambilini-ke inkantolo engakuzwisisanga ukuthi bingamzwisisi u-advocate Tifo uma ngabe esithi unumber 1 nonumber 2 babengaphandle nkathi beboshwa. Kusho ukuthi-ke okufanele ukuthi kwenziwa inkantolo uma ngaba umuntu evela kufanele imphinde imdedele futhi noma ngaba izimo zona zithi kufanele agcinwe ngaphakathi estokisini. Kunye futhi-ke akushilo ukuthi-ke uyena u-advocate Baloyi uyilahlekisile le nkantolo ngokuthi ayitshele ukuthi umangalelo wokuqala nowesibili ukuthi noma-ke abagcinwe ngaphakathi estokisini. Inkantolo-ke ibisiveza-ke ekugcineni-ke ukuthi lo daba lolu-ke kofanele-ke udingidwe ngendlela eyahlukile, yila iseyichaza khona-ke ukuthi kuzofanele kutholwe usuku. Ngicabanga ukuthi leso-ke isizathu esibangela sibe khona namhlanje noma ilanga-ke la khona-ke konke kuzobhalwa phansi, hhayi ngendlela ekwenzeke ngakhona izolo, kodwa konke kubhalwe phansi kubese-ke kuyavunyelwana-ke ukuthi kuzoziwa enkantolo, ibese inkantolo ibe yiyona-ke ethatha isinqumo ukuthi inqubekela phambili iya ngakuphi na. Uma ke sesindlulela manje ekuqeda ukushiwa uyena ke uadvocate uTifo, uqale ke umshushisi wasukuma ke wayitshela inkantolo ukuthi ke asibanga khona ke isivumelwano mayelana nelanga icala elingahlehliselwa lona, wabeseshoko ukuthi uadvocate Tifo uyena ke ozothi bese lichaza ke lo daba enkantolo ukuthi isizathu yini. Uadvocate Tifo ke uphendulile ke washo ukuthi uzokhuluma kanye ngalo dokotela lesibini elu375. Wavuma ke futhi nokuthi nge-23 zika March kuwana lo nyaka wayekhona ehhovisi lakhe uadvocate Baloyi, wavuma futhi ukuthi walithola futhi ke babe kanye naye uKenneth Buthelezi, esho nokuthi futhi kwaku warrant officer Makhubo uyena ke owavula ke lelo dokodo elu375 ngokumayelana nesehlakalo esenzeka kwa13511 eKutlwanong Street. Washo futhi ukuthi leli idokodo eliphambi kwenkantolo manje u636 lona ke lavula uyena uConstable T Mathebula owayepolice station yaseFosloras nge-26 zika October 2014. Idokodo lona u636 lavulelwa esibhedlele eButhilong emuva kokuthi uMathebula kanye nozakwabo bahamba ke noma ke babe amaphoyisa oqala ukufika kwindawo yesehlakalo, babe sebetshelwa ke ukuthi ukhona ke owadutshulwa futhi usethathiwe ke wahanjiswa ngemoto yakhe bamhambisa khona esibhedlele, futhi imoto leyo yakhe yayishayelwa uyena uNonhlanhla Kelly Khumalo. Babe sebehamba ke uma befika ke esibhedlele bamthatha bamusa kwigumbi noma ke kwiward la wayeleli khona ke ila bathola khona ke ukuthi useshonile futhi ushone ngokuthi adutshule. Futhi ke ngokwezimo ezenzeka ke ku636 nongendlela ke awavulwa ngayo u636, uyena ke warrant officer Makhubo wamaHawks uyena ke owumangali noma owavula lelo dokotela. Warrant officer Makhuba yena ke angaza azochazela lenkantolo ngalo idokodo ele37501/2019 uma ngabe isidingo sikhona. uKenneth Buthelezi kanye naye uwarrant officer Makhubo bazobabiza ke bebizwa uyena ummangalelo wokuqala, number 2, number 3 no number 4 ukuthi bazoba ofakazi babo ngokumayelana nalelo dokodo ele37511 ka2019. Okunye okusha ke akushilo noma athi osanda ukuthola ke ukuthi lecala eliphambi kwenkantolo manje selinabaseshi abasha, ubrigadier noma uKenneth Gininda, futhi ke likhona nethimba asebenzisana nalo, futhi ke unezitatimende ezimbili ezifungelwe ama-affidavits awabhalile mayela nophenyo lakhe ngaleli cala.
Yes.
Thank you, Rashid. As I said, I can confirm, Rashid, that on the 23rd of March 2022, I was at the office of Advocate George Baloyi, the state, together with Warrant Officer Makhubo, as well as Lieutenant Kenneth Buthelezi, whereby the arrangement was made that when I receive the disclosure of 375, we should meet at the office of Advocate Baloyi. And Makhubo and Buthelezi, they complied with the request that I've made. That's where the docket 375 was handed to me on the 23rd of March 2022. Interpreter?
No, go on. He will.
I should continue?
Yeah.
Okay. All right. Yes. Okay. So I got the docket on that day, Your Lordship. It was even, Advocate Baloyi, because I liaised with him and I indicated to him, it was after the 17th of March this year, during the disclosure of the dockets when we were taking over as the defense of 1 to 4. It was before your brother, Your Lordship, Justice Baum, when the disclosure was made. And the same day, I also pleaded that I'm not only here for 636 disclosure, I'm also here for 375. And the Honorable Justice Baum asked Advocate Baloyi to comment about 375 because it was not docket which was given to the adjudicators of legal aid. By that time, Your Lordship, when we take over on the 17th, we took over from the adjudicators of legal aid. Every accused that we are representing now, accused 1 was allocated his judicare, 2 his judicare until accused 4. And as for accused 5, she has been with Advocate Msololo since 2020. Then arrangement was made, Your Lordship, on the 17th of March, as per request of your brother, Justice Baum, that you made it categorically clear to Advocate Baloyi that there is now a new defense counsel, or totally the new defense, the private defense for 1 to 4. So the trial was going to commence on the 11th of April, same year. And for the purpose of a trial to commence without the hiccups, Judge Baum made it clear to Advocate Baloyi that let the defense get everything that they may need. And Baloyi promised to cooperate with the defense of 1 to 4 on that day. We were in court GA, Your Lordship, by that time. And then further, there was a ruling from Judge Baum that as a new defense, we should make indication regarding our readiness. And there must be a confirmation in writing on or before the 28th of March that we are ready to proceed on the 11th of April. It was the reason, Your Lordship, that I was always time and again on the neck of the state in order to get docket 375. It was when on the 23rd of March, as per arrangement done by Advocate Baloyi, that Lieutenant Colonel Buthelezi and Warrant Officer Makubu, they should come to their office, to his office, where he will be meeting me to give me the disclosure of 375. Indeed, it happened, and I got it. And before then, I've been told that Advocate Baloyi was in possession of 375 as early as January 2020. As a prosecutor. So he was in possession of both dockets, 636 and 375. It was only after Advocate Baloyi prosecuted 5 accused on 636. And leave 375 as it was. And 636, it was prosecuted on the basis of the persuasion and information by Brigadier Kininda, who was the new investigating officer in the 636.
Can I get clarity? Did he stand instructed by the DPP to pursue both? Because I would understand that some instruction would come from the DPP for Advocate Baloyi in his capacity as a prosecutor to pursue prosecution on given cases.
Yeah.
So are you saying that he was instructed to conduct prosecution on 2 dockets, which happened to be about one and the same incident, and he chose 375? Is that what you are saying?
Okay. Thank you for that, Lordship. Let me make it clarity. Yeah. Firstly, let me bring this to the attention of the Honorable Court, that myself, I was appointed as a watching brief before I became the defense of 1 to 4. I became the watching brief I was appointed by the brother of the deceased, Senzo Meyiwa. That was it was in September, if I'm not mistaken, September, if not August of 2020. So I became that watching brief on 375/01/2019. That was opened whereby the investigating officer was Makubo and Utelezi.
Yeah.
Hence,
I'm patiently waiting for the answer to the question I put.
Okay, yes. The reason I'm addressing this is that I can come to that answer, to give to respond to that. Initially, by the time I became the watching brief, and I started to, I was informed, I was introduced by Sifiso to the NPA. I was introduced to the police as well. Then, by that time, 375 was assigned to Advocate Vincent Nzuke. Actually, all of them, all the dockets, were with Advocate Nzuke. Is the person mentioned on paragraph 3 on the 2 letters as a junior state advocate? Yeah, Mr. Chauke has just been disingenuous. Vincent Nzuke is not a junior state advocate, he's a senior. He's at the High Court. So,
Are you going to come to the answer to my question?
isn't the question was that were the two dockets allocated to Advocate Baloyi for decision? Is that the
No,
question?
no.
Maybe I be reminded.
The question is, are you saying to me that the DPP instructed prosecution to happen on both docket number 1 and docket number 2?
Oh, no.
And
Only-
that's the answer I needed all this time.
Okay. Yes, okay. Actually, as per my instruction as the watching brief, the instruction of the family I was representing, the Meyiwa family, and I'm still representing that family on 375.
Before you continue, you said no. On which one, according to your knowledge, on which one was instruction to prosecute issued?
On 375.
Yes.
Yes, it is. On 375, and then the instructions or the directive were given to Advocate Vincent Nzuke.
Yes.
And then, for the reasons unknown, it was on the 26th of October 2020, where there was a press conference of the Minister of Police and the senior management of South African Police Service. That will be the former National Commissioner, Ketla Sitole, and his deputy, by then the late Lieutenant General Mfazi, where it was made known to the whole nation that there is a breakthrough on the murder of the late Senzo Meyiwa, whereby 5 accused have been arrested. Suspects have been arrested because they were suspect by then on the 26th because they haven't appeared before the court. And furthermore, the Minister of Police went further to say, we South African Police Service, we've got a watertight case against the 5 accused. And then that's when, Your Lordship, on the 27th of October 2020, the accused before this court appear in Boksburg, whereby the prosecutor became Advocate Baloyi. And to
Can you give me clarity? I'm asking this question because I think the other day you were starting to tell me that you were in the police force and I stopped you.
yes, I
Now
remember.
I find myself having to tell you that I was once
The previous
prosecutor-
life.
That I was once a prosecutor and dockets get allocated. In my situation, whoever was the senior or the control prosecutor would give me a docket, and if it has not started at any stage before it starts, it could be taken away from me and given to somebody who would be seen to have space to deal with the docket on a speedier basis as compared to me. Now, you are mentioning the change of prosecutors from Advocate Nzoki to Advocate Baloyi. I just want to know the sense you are conveying. Are you saying that should not have happened, or are you just relating it as part of the history of this case?
Yeah, actually, thank you, Lordship. Actually, that took the investigating officer of 375 by surprise. It took me by surprise as the watching brief. It took them, the Meyiwa family, as a surprise that the arrested 5 people were based on 636, and it was on Baloyi by that time.
Are you saying that should not have happened?
That should not have happened.
And why? Why do you argue that it should not have happened?
It should not have happened because that did not happen in a good spirit, as your Lordship may say, the example that you gave me. And then I also want to bring this court up to speed in relation to this scenario is not usual, your Lordship, whereby there will be the 2 dockets. Actually, during the time when 375 was with the Advocate Nzuki, all these dockets were together with Advocate Nzuki, and he made this decision in terms of Exhibit C on the basis of him having read docket 636 combined or in conjunction with 375. That's when this so-called draft, according to Advocate Baloyi, which is the Exhibit C, came into existence. And as on top of it, Exhibit C, it says, inquiries v. Nzuki. I did, in my capacity as a watching brief, speak to Advocate Nzuki, a very dedicated public servant, a committed prosecutor.
Okay, let's not lay out the CV of Advocate Nzuki. Go to the point.
Okay. No, I'm just saying this, that's my realization
I
about
can
it.
see you are impressed with him, but
Very much.
yeah, please contain yourself.
Okay, sir. Okay. Your Lordship, I'm advised that it's about the tea time, so may it be the opportune moment?
11 minutes before tea.
Okay. All right.
You're instructing attorney may be thirsty for tea, but let's proceed.
Sorry to interrupt, my lord. I just wanted to give some instruction, hence I wanted to adjourn.
Yeah, so
this
be
one.
honest.
Yes.
Don't cite
Please,
don't cite tea that there isn't.
The reason being why I wanted to instruct him is to summarize issues.
I appreciate that, but let us be truthful in
Unfortunately, my watch says 11 because I always put it up front 10 minutes. I realized
It says-
now 5 past 11. Hence, I was
tea
using my watch.
tea time is 11:15. Advocate Michelle, Advocate Valoy, they need a short adjournment which will go into tea time so that there be instructions by the attorney.
I have no objection, my lord.
As it please the court, Your Lordship. However, Your Lordship, before I can start, there's some incident here.
Yeah.
There is a gentleman here at the back here. During the break, he came here and approached the state. He said he's from the police. And then he wants the names of our client here. And then, under every name of the accused, be a brief. Where is this person incarcerated? And the address at home. Where is he coming from? And he said he's been sent. It's a Lieutenant Colonel Fori. He has been sent by the generals and the Minister of Police to come and obtain this information. So I said he should come. I will inform the court and then address the court, his purpose here. What is the purpose of those generals from the police as well as the Minister of Police sent him to come and take the names of our client here? As it is a common cause now that our witnesses, even our accused, their lives are threatened.
You say it's
Lieutenant Colonel Fori from Inspectorate.
Bafethu ke okudluliswa ummeli wenu lana ukuthi ke ngalenkathi ke inkantolo isaphumile ke kunobaba ke noma kunomlisa ke lana oye wangena la enkantolo wase eya ke kumshushisi esecela ke amagama enu nonke ningabasolwa ke futhi ke namakheli enu nala futhi ke nigcinwe khona estoksini uthi nje akangidlulise lokho ke kumehlulela ukuthi akwazi ukuthi kunaleso sahlakalo senzekile uthi ke uLieutenant Colonel Fori uhlezi lapha ya emuva.
We strongly believe that this is a part of this intimidation that is happening against the defense.
Okunye futhi engakushonga ukuthi ke lokho ukusho ke noma ke ekwenza lokho ke uthi ke uthunywe abaphethe emaphoyiseni kanye futhi naye ke ungqongqoshe wamaphoyisa yibona abamthumile ukuthi ke azoyothola leyo mininingwane futhi umela akazi ke ukuthi yini inhloso yokuthi ke bamthume ngemininingwane yenu futhi siyazi ke ukuthi ofakazi benu kanye futhi nani ke impilo yenu isengcupheni.
So what is the interest of the generals in the police as well as the Minister of Police to our clients and their background, where they are coming from? So I would like to request him to come and tell this court what is his purpose. Mr. Fore, can you come here?
No.
Apologies. Apology, Lordship. Apology, Lordship.
Mr. Defo,
Lordship.
when you become judge, I will never be within 2 kilometers of your court. I will stay far away.
God save South Africa.
Advocate Mshololo.
No, my lord, I've got no submissions. I've never had such information.
Advocate Baloi, I would be more reluctant than I am now to entertain this, but we have, as you know, we have had some incident involving members of the police visiting, for lack of any other word, our courtroom My concern is the courtroom. I don't know whether you have something to say about the submission made.
Malota was just out during the short adjournment. My learned friend can address that issue.
Oh, okay. By the way, it's Advocate
Sibanda.
Yes.
My lord, I can confirm that a gentleman who introduced himself as Lieutenant Colonel Fori from Division Inspectorate from the South African Police came to see me during the short adjournment that we had, and he indicated to me that he wanted to know the case number as well as the name of the suspect. I did not hear him asking for the addresses as well as the fact that the minister sent him to come and get those details. Maybe I might have missed that point, but during my short interaction with him, he did not mention that aspect. And I also asked him for who sent you. He said his seniors, and further said generals. And that's when Advocate therefore greeted him. He said, hi, Fori or Addition Fori, and that's when I withdrew from the conversation as a court place.
So that's all you had.
That's what I heard.
Advocate, therefore, so what do you want out of this story?
Your Lordship.
What do you want?
I'm skeptic, Your Lordship, because as my learned colleague here said he had up to so far, I took it further with him because I was concerned if he can approach the state and say he needs the names of our client. Because I indicated to him that the client is not about the state. The accused is not about the state. The accused is about the defense. I'm the defense here. That's where the part that my learned colleague, Advocate Sibanda, didn't hear, that one of the minister, as he corroborated me. As for the generals, yes. Yes, because I asked him, what do you want? Then, Your Lordship, this information is crucial for the court to be aware, as we've already put it on record that the defense in this regard, 1 to 4, we are getting the threats. And we never even beat around the bush as from where the threats, the source of threats is. He said it's from the state, including the police.
My difficulty, Advocate, therefore, is that we are busy with case number CC67 of 2020, where the accused is Mr. Sivia and his co-accused, 5 of them. And this incident, according to you, happened over a break of these proceedings.
That's correct.
What is of concern to me is only that it happened inside the courtroom, of which I would have expected the state to deal with that. If I start calling people, you'll go out over lunch and hear somebody commenting and said, come back and say, please call him, so that we ask him. So we will be all over. because of what happened in the past, I have some bit of concern about what you are mentioning. But I don't think I should call Lieutenant Colonel Fori. I could even go as far as giving the state the chance to interact with him. I don't want to create an impression that Mr. Fori was on trial today because of something that happened during break. Had it not been for the incident I keep on talking about, I would even tell you that it has nothing to do with me. But because something happened inside the courtroom, about which I don't want to pronounce anything, I would think that it is prudent for Advocate Baloyi and his colleague and yourself to interact with Lieutenant Colonel Fori. Lieutenant Colonel, for me, is a bit of a higher rank. And I think when we pronounce on such people, we have to be very sure of what we are doing. And that's why I want that interaction, so that when I'm briefed in terms of the way forward, but I must say now to you that I'm very reluctant to hold Lieutenant Colonel Fori over the coals by calling him, even the way you were calling him. I'm very reluctant to do that.
No, I hear you.
Advocate Mshololo, if you are interested, you can include yourself. But for now, I'm giving a short adjournment. In my experience in matters of the law in courts, it is so that members of other disciplines, social workers, maintenance investigators, and in this case the police, do find themselves in the areas of courtrooms, of courthouses, not courtrooms, for the one or the other reason. But that has to have limits. And I do not undermine the concern you have, but I am reluctant to go about it the way you suggest, that I call him and ask him, Mr. Fori, why are you here, and why do you want details of one of the accused? I don't know. I don't know how that person led their life before they became an accused in this case. And I don't know how other people outside are behaving, which would bring necessity for that to happen. But added to my concern is also what you are mentioning, that there was, which is not being corroborated by our colleague here. Yeah, that the name of the Minister of Police was also mentioned.
No, not the names, the ranks. The ranks in position.
Oh.
So generals and minister of police.
Yeah, no. The minister, the ranks have been confirmed. I'm saying
Yes.
what is of further concern to me is that there is mention of the name of the minister, and I don't want to be part of a situation casting aspersions without a basis.
Yeah. No, Your Lordship, for the purpose of our progress here, I was just bringing that to the attention of the court. It's recorded. I'm satisfied. I will take it further with with the state.
All right. Okay.
Yeah, I can continue.
Okay.
Yes, Your Lordship, the reason for me to mention the name of Deputy Director of Public Prosecution Advocate Nzuki. It was for the purpose of Exhibit 1 to Exhibit C1 to C2, as I will be now addressing the court in relation to them. To start with Exhibit C1, which was the first letter with the contents as per the request. Okay, however, before I come to that one, Your Lordship, let me just finalize in response to the issue of the docket. Other important thing that I left out was that on the 17th of March, during the time of the disclosure year, there was Mr. Sevilla, the attorney, the instructing attorney of Advocate Mshololo. We engaged, and he also been informed. Actually, it was him who was anxious to know about why, when you were addressing the court, you talk about the two dockets, 375. I explained to him my position on that docket. Then that's where he said, okay, no, he's satisfied because he's got the background of this matter. As I said, they started with this matter as far as 2020, 636. So to him, it was not of concern, or it was not important. 375 was not important because it was not the case that was before this court, as per Mr. Sevilla, the attorney of, instructing attorney of Advocate Mshololo. And even after the 23rd, Your Lordship, after I got the docket, I phoned Sevilla because he was also of the concern, and he, as I said, he was like appreciating that if indeed this matter should start as soon as possible on the 11th of April, there should no thing that's disturbing. And I informed him that I got the docket. Is that important part that I forgot? And further to that, actually, is further supporting what Advocate Baloyi said, that on the 22, when the state put the charges on our client, it was still the confirmation that docket 375 was not of importance to accused number 5. So it came as a surprise last week, Wednesday, when I was not at this court, that now the 375 is an issue insofar as accused number 5 is concerned. Thank you, Your Lordship. Then I'm coming to Exhibit 1 and 2, starting with 1. The subject, yeah, C1 and C2. We are of concern about these two alleged exhibits, insofar as their contents are concerned, especially, let me start with this because these have been accepted as two of them. The subject of C1 and this letter, it seems, is directed to, says, Dear Advocate Mzinyati. Advocate Mzinyati is a DPP Pretoria. Clarity sought regarding purported correspondence from DPP South Gauteng in the murder trial Mr. Senzo Meyiwa, as per Phosphorus Cast 636/10/2011-4. Of concern, it will be paragraph 2 and 3. Which is already on record, Your Lordship. But now, just to get into the merit of this content. It would appear as that the need to entertain the docket 636. And paragraph says, this office did not make any decision or otherwise regarding the case docket. Paragraph 3, the alleged documents do not have any status as such was an internal opinion from a junior state advocate which was without merit. And the author is M.A. Chauke, Director of Public Prosecution, Gauteng Local Division, Johannesburg, dated the 10th of September 2022. The person who requested this document is Advocate Mushololo. But here, the writer is addressing Advocate Mzinyati, his fellow counterpart in Pretoria Division. And he signed on the 10th of September, June 2022, saying that, by the way, Your Lordship, is about Exhibit C. This one of Advocate Nzuki. Number one, I've said, if the purported junior state advocate is referring to Advocate Nzuki, I want to categorically make it clear to this court that Advocate Chauke has been disingenuous. Advocate Nzuki is not a junior. He's a very senior. And he's got the right to make a decision if he has assigned the duties. During the time when Advocate Nzuki was drafting that, as it's called by Advocate Baloyi, a draft, this Exhibit C, he had a title to prosecute, but he was not allowed to prosecute. He drafted indictment, but he didn't finish. Instead of finishing it, it was taken from him by Advocate Chauke and took the docket to Advocate Baloyi to Pretoria. Actually, DPP Johannesburg transferred the case docket, which was supposed to have been prosecuted by Advocate Nzuki, to Pretoria without a proper authority of the NDPP for that matter. So hence we say this is disingenuous to say, never mind Exhibit C. It was just opinion of junior state advocate who was bored.
As a court pleases, my lord, I'm sorry to interrupt my learned friend, but I'm just worried that information is being given from the bar that need perhaps to be put before court by way of affidavit. And I'm also worried that people's names are being mentioned and linked to certain actions which perhaps they might have a version on that, my lord. And I therefore request with the greatest of respect, my lord, that perhaps the current process should preferably be dealt by way of affidavits, my lord, instead of the current process. As a court, please.
As it please the court, Your Lordship.
Advocate Tefo,
Yes.
earlier on I asked you, are you giving evidence? You said, no, I'm giving background. Now it's going to details, mentioning names and so forth. And for the life of me, I don't know what we are doing now. And I don't know what you expect me to do with this information, because much as you said it loudly, audibly, this information is not really before me, because it did not properly come onto the record. It is you, I think we have been saying this from a number of days in the past, that you as an advocate cannot come here and give evidence. And you say you are giving background, yet you are giving details and names and all that. And I'm also concerned now that the fact that I'm listening to you may give you an impression that I'm going to do something with the information you are giving me. Yet we have agreed that Advocate Mshololo will complete what she is doing, and when she has done that, you will have all the time to say what you need to say. And it is amounting to another disturbance of Advocate Mshololo. And this time, even your attorney agrees with that interjection. I've been restraining myself from saying this, but let me inform you that personally, I don't know of any institution or university that will give certificates to women only for them to come into our courtrooms and listen to males speaking at will. I said it from yesterday that why don't you await your turn? Because now you have given me a lot that should not be before me, because it's not coming properly. I asked you as a way of trying to warn you at the beginning, are you giving evidence? Because that is exactly what you are doing for the past hour or so. Yet you say you are in a hurry for this case to proceed. When I speak, you don't interject. When Advocate Baloyi speaks, you don't interject. When your instructing attorney speaks, you don't interject. When Advocate Mshololo is busy with a point and a process, you interject today, you interject tomorrow, you interject day after tomorrow. And it cannot be right. I am a lawyer. Advocate Baloyi is a lawyer. You are a lawyer. Your instructing attorney is a lawyer. Advocate Mshololo, we may be uncomfortable with it. She's a lawyer, and she has a client. And I don't know why you insist on coming in between each time she needs to carry a particular process before this court. And I keep on saying, I'm not rushing anywhere. Nobody's rushing anywhere. When she is done, you would be given all the time to follow these processes. And when all this information will come properly, I would be expected to listen to it again if I need to note it again. How fair a process is that?
Your Lordship, in my response, actually, even myself, I try by all means, and I've restrained myself, and I may not know why it should happen that when I'm trying everything to avoid to make an argument with a court, that will happen. Well, I'm supposed to make an argument with the state, because here, I have never responded. Yesterday, it was Advocate Baloyi, it was Advocate Mshololo. I understand. This was raised in my absence, and it doesn't mean that I'm excluded. I was the person who was implicated that. There is an impression that has been created that even the so-called people who are commenting, the so-called legal expert, are commenting, especially about me insofar as the impression has been created about docket 375, that Tefu is having that docket 375 because he had advantage, because in his previous life, he was a police officer. He spoke to the police officers, he's got a connection. That's why he had advantage.
You see now, you are going to carry things in the media. Come and make them part of the argument here. I don't know.
I've not
listened to that, and none of your colleagues has put it the way you are putting it.
I'm not carrying anything from the media, Lordship.
But then why are you
saying.
Yes.
There is impression that has been created by Advocate Valoyi to say, let me finish, Lordship, that he was not honest when he said, if the court can remember, even yesterday, when he was talking about the date when this 375 was received, he said at the end of March. I corrected him, I said it was the 23rd because I was there. And this was arranged officially and properly without any sinister means. There was no sinister means.
If I may ask you a short
And then when it comes that I am the only one.
As you stand there, you will continue. What are you doing? Or what do you expect me to do with all that? For the past hour, you have been addressing me.
I'm responding, I'm replying, yes, I'm replying to what has been said about the defense of 1 to 4, that the defense of 1 to 4 has got this, and the state never knew. But Lois said he also becoming aware of 375 today, as he was explaining yesterday, last week, which is not true.
You are responding by way of giving evidence from the bar. That is the issue. That there's nothing wrong with all that you are saying, provided it comes properly before court. You are giving me a story with details and names, and you are saying it from the bar. And there is a proper way of doing that. And it may be very necessary for you to do that. But you are doing it in a way that I don't have a basis to recognize what you are telling me.
Your Lordship, I don't believe that it can be now called I'm saying this from the bar when I have to respond to the existing document, which are even labeled.
You only touched these documents now late the past 10 or 15 minutes. The rest of the hour and over that you were addressing me, you were telling me about other things.
Responding.
Other things.
Responding.
Yeah, you were responding, but
Yeah.
you were responding about other things. And I don't, like I keep on asking you, what do you expect me to do with all that you're giving me? Because it's not supposed to be before me because of the way it is coming. And there is a way, I want to repeat, there is a way of bringing all that information before court, a proper way that lawyers should follow. Lawyers like you are bound to follow that. Lawyers like me are bound to recognize it if it comes in a proper way.
Your Lordship, I will say, for the clarity, and I was of impression, and I'm still of that impression, that we're just being swayed by the small thing from the state that trying to protect himself. The thing is that all I've been saying, it was the response in relation to the impression that state was not aware of 375, Mshololo was not aware of 375. All these people, they've been aware of that. But now, I was stigmatized to say I'm the only one who had that because I've used the connection. This goes to the extent that Lieutenant Colonel Butilis and Warrant Officer Makubu, they can be charged to say, why did you do favor to Advocate Tefu, the Defense Counsel of 1 to 4? This is the impression that they created, and it was the way.
Gave you a clear indication that this has to be followed up properly in compliance with the obtaining procedures. That is why I said yesterday already that I even gave points that have to be followed. That even include all that you have been telling us about for the past hour and so, that this be followed up. I even said, if it needs be, those that are responsible may have to come. I even said I'm not prescribing, may have to come and clarify the court. Now, you are giving everything that all those people, when they come, have to speak about, everything that you may have to cross-examine about when they come. Now you are giving evidence before they come and give evidence so that you can cross-examine and tease out these issues, just the way your colleague Mjololo did. She teased out issues under cross-examination because they were not brought in the evidence in chief of the state. Now you are giving, I don't know what to call it, you are giving something that you should hold back on, allow those people, if they will come, challenge the way the evidence is brought if you think it's not enough, and then take the matter forward.
Your Lordship, you are correct, insofar as the people who may need to come here is concerned. Because it cannot now that, it may not be known who should come, because if we didn't deal with this matter, if I didn't respond to the impression, to the negative impression that I am the only one who got favor insofar as 375 is concerned, and it has been said, it is without a merit, 375, by Chauke. And the Chauke, Your Lordship, for the information of this Honorable Court, Chauke is not the author of Exhibit C.
You are giving me evidence. You are giving me evidence. And you, earlier on in your address, you did give indication which gives that impression that Chauke is not the author. Now you are giving evidence.
If I don't mention that, because it's for this court to know.
You can mention it under cross-examination. If the wrong person comes here, you can mention it.
Am I going to, is a Chauke a witness in this case?
If Chauke doesn't come, you are going to deal with that. You are a lawyer. You'll deal with it.
Your Lordship, I don't agree, definitely, with due respect. And I've asked my attorney here to honestly and humbly ask you so that we can reply to this impression, that negative impression that is created by Baloyi. It was Mshololo yesterday saying, Baloyi is a liar. I never said that. And if it was me saying liar, I could have been reprimanded. And this is not fair, because if it comes to that, I become to realize that there is some biasness insofar as this court is concerned. I was supposed to be allowed, because today is our day to address for the 1 to 4
What
to address.
what will I do with what you are giving me? I'm telling you, it is not evidence. For it to be evidence, you know, I don't have to repeat, you know what to do.
I'm replying, yes.
You are?
I'm replying to the state in relation to the docket 375, because paragraph 3, it says, the docket was without a merit. And let me tell the court this, maybe it will be understandable. Firstly, for the very first time, I've informed this court that when it started, I was appointed as a watching brief on 375.
No, you are repeating that.
And I'm still the one.
You have already
Yes.
said that.
And then number 2.
Go forward from where you left it.
Okay.
That's where we fight, me and you, because you say things and you say others. Later you go back to what you have told me, and I have to note all that.
There is a need, Your Lordship, to sometimes when we are engaging, and it seems as if the certain important information has not been captured, it's very important to remind the court.
Captured by whom?
By the court. I'm talking to the
But
court now.
I'm telling you, I captured it.
All right, yes. So in that, it is in that sense that I have to reply, because there is a new instruction, as Baloyi has
Yes,
said
yeah.
that.
Now we are speaking about a new instruction. Go to it. Go to
Okay,
that.
thank you. Our qualms, Your Lordship, about the Exhibit C1 and 2. If insofar as my learned colleague, Advocate Moshololo, is concerned in asking the postponement in this matter to go and engage or acquaint herself with the contents of 375, we don't see that need. The reason I'm replying is that of most important is because this honorable court has not yet made the judgment or the ruling insofar as the requested postponement by Advocate Msholele is concerned in relation to this document, as per her understanding. Is the reason I'm here, and I requested my attorney to plead with this court for me to reply. Why we are saying that it may not be of importance. If the DPP, Johannesburg, Advocate Chauke, in relation to 375, he can say it is without the merit, and it was opinion of a junior advocate, state advocate. This is not true, and this is hampering into the interest of our client, Senzo Meyiwa, insofar as the justice is concerned, because these two letters are not doing justice to the Meyiwa family. If we can go to that contemplated postponement, why would Advocate Mshololo want to take this further if Chauke said this does not have merit? This is our call. And then, after she finished reading this, she was told, the court was told that, no, there was another version of another letter that wanted to correct, to say, we are not talking about 636, we are talking about 375. Then that's when the C2 came, Your Lordship. C2 is even worse insofar as our grievance is concerned. But the contents are just saying the same, but the different is the case docket. It's 375 in here. C1 was signed on the 10th of June 2022 by Chauke. And then this happened within 10 minutes. It was then we were introduced to C2, that is a corrected version. Insofar as 636 is concerned, it was then corrected version is the 375. 375 says, paragraph 2. This office did not make any decision or otherwise regarding the case docket, First Loras, CAS 375, 1/2019. We agree. The decision was not made. And it is in this spirit that paragraph 2, that decision was not made, insofar as 375 is concerned. We've got a new instruction that we are going to pronounce to this court from the Meyiwa family. And then number 3, it says the alleged documents do not have any status as such, was an internal opinion from a junior. It is, as I said, it's the same, but just the difference is here we are addressing 375. And we still of the same spirit that we are objecting to what Mr. Chauke is saying. And so far, also, he's not. He's talking about the author of Exhibit C, which we believe, that, which even our client believe in that the people at the house are the one who are supposed to be charged, not our client. And then furthermore, I don't know, Advocate Valoy will address us later. The corrected version of, which is a 375, is signed by M.H. Chauke, the same DPP Johannesburg, date 13 June 2020. Actually, it was signed yesterday as compared to C1. And this was signed, I don't know whether Chauke was on the passage here, Within 10 minutes, Chauke signed here. The signature specimen here, we consider it to be fraudulent. We have looked this, we went through this, and the only answer, the relevant answer to quash our suspicion can be dealt by the question document. We are prepared, if push comes to shove, to open the case of alleged fraud. The Chauke's signature has been defrauded here. Hence, according to us, Your Lordship, according to accused 1 to 4, this Exhibit C1 and Exhibit C2, they are the bone of contention. There should be no decision taken on the basis of this because the contemplated application by my learned colleague, Advocate Mshololo, will be informed by this document. And for that matter, we're still saying that Advocate Vincent Nzuke has the title. At the time when he was drafting this Exhibit C, he had the title to prosecute. And as a result, something unbecoming has happened. And normally people don't want to call the things by their names, the way they are. Because sometimes it's becoming taboo in this country to say the things the way they are. These documents are representation of the corruption that happened in the office of the DPP Johannesburg. There is a cover-up insofar as these two documents are concerned. And as I mentioned, Your Lordship, we are saying this, as I said, we are saying this before this court. What I've said, with the due respect to Your Lordship, is because the decision or the judgment has not been made to say Advocate Mshololo should bring the application. And that application, we don't know what is that application, because after Advocate Mshololo has read the docket, these documents, she said, because she has agreed with these two exhibits. And then she said, I'm satisfied with this document, Your Lordship. Therefore, Mosia could be brought back and I cross-examine her. I'm satisfied. So, all of a sudden, there is application that need to be done. For what purpose, we don't know. I move on. Because we don't believe that if the docket cannot have the merit according to the Chauke, what is the need of interrogating that docket? It's nothing but a waste of time. And that contemplated application will be frivolous. Is that pity to us that this is a criminal proceedings. But if it was in terms of the civil proceedings, we were to say, Advocate Mshololo want to waste the time of this court, and there should be the cost against her. But in criminal, doesn't work like that. People are not get punished, unfortunately. And the people will be, people's time, our client will still remain in court, in incarceration until September. It will be unfortunate. As I promised this court, Your Lordship, that there is also, insofar as the state is concerned, we also become aware of the fact that it's a fact to us, or let me put it, it's an allegation that Advocate Waloi, he does not have title to prosecute. in this matter. And I'm going to substantiate why. And I've got a statement here, affidavit, that I will read for the record, which it will be the document that we conclude with, putting our case to the state, that we say, Advocate Valoy, he does not have a title to prosecute. Our client were arrested with the warrant of arrest. They were issued. You even arrest someone who is already in incarceration. The person is serving sentence for the different matter. Then you issue warrant of arrest for that person. Warrant of arrest for what? He will tell. Insofar as the procedure that I know, Your Lordship.
If I may ask you just a short question. If the police are busy investigating a case and they discover that the suspect is in custody, and they discover that the suspect is due to be released tomorrow, what should they do? They should leave it and the accused or the suspect is released and then start and say, now he has been released, we are going to look for him. Is that how it happens? I'm saying so because where there is such a situation, I know that an arrest may be announced to the suspect whilst in custody, and the presiding officer who may be releasing the suspect will be made aware that there is another warrant of arrest to avoid that person going. Sometimes it's a person who is not even a citizen. Releasing that person will go forever. So your suggestion is that under such circumstances, such people should be allowed to go, and the police will then tell each other, hey, he or she has been released, let's go and look for him.
I would be reluctantly want to answer that question of the court, Your Lordship, because that question is aiming to distract me.
Okay.
Yes. So, yeah, I'm specific. I'm talking about this case. Our client, accused 3 and 4, are serving long sentence for the different matter. They are still serving their sentences, and they are on the process of appealing.
No, I'm not talking about your clients. I'm talking about the practice.
Yes.
The practice.
No, me, I'm talking about my client.
Yeah, but why is it when you have issues, we have to entertain them? When I have issues, they are not worth entertaining.
No, like,
what kind of approach is that?
Like I'm saying, Your Lordship, I say with a due respect.
Because later you will want me to apply my mind to this, and these are issues that are coming to my mind as you are addressing me, and you are saying no, you cannot engage in that because it will destroy you.
Okay. For the sake of progress, Your Lordship, all right. Let me hasten to say, I'm now back. Let me entertain that answer so that we can progress. I see that if I'm reluctant to answer, that's where we cannot progress. In that scenario like that, when someone is about to be released tomorrow, it means that the arresting officer, whoever is investigating officer, is aware if that person is being released tomorrow. And then the procedure is that the issue is that you know where is the suspect. Is incarcerated in Correctional Center C. So you go there, you approach the head of the prison, and then you'll have the so-called requisition. You cannot have the warrant of arrest. So in this case, in our case, because each and every case, Your Lordship, has got its own merit, but in our instance, accused 3 and 4, they could not have been approached with a warrant of arrest. They should have been approached with a requisition to the head of the prison. So they were not even aware that they were arrested with a warrant of arrest. They were surprised when we tell them that the warrants of arrest were issued by Advocate Baloyi. Applied for.
A requisition.
Applied for.
A requisition has capacity to place somebody in custody.
Requisition is invite for the IO to can go and negotiate with the prison authority to say, the person I'm looking for is in your center. That is allowed. So now when you go to arrest the person who is in the correction center with a warrant of arrest, you went to extreme. So in this regard, Your Lordship, as I was about to concentrate on this document of which say, in essence, at the time, because those warrant of arrest, according to those people who arrested them, they were arrested on the 26th of October 2020. And 6 people, not 5 people, were supposed to be arrested. And for the reason unknown, the 6th person's warrant of arrest was no longer executed. And the 6th person, according to the case docket 375, it's accused number 2, Kelly Kumalo, in the 375. But here, it has been made that Kelly Kumalo could have been arrested together with 5 accused on the 26th of October 2020 for conspiring, conspiracy to murder, and the murder of Senzo Meyiwa. So what made my learned colleague, Advocate Baloyi, to hold back the warrant of arrest of Kelly Kumalo, which was prepared the same time with the warrant that we were used to arrest our client here, the 5 accused before this court. Then, furthermore, Kelly Kumalo has been deeply implicated as the trigger point to the murder of the deceased, with 5 accused here. And I would like to remind this court insofar as the theory of case 636 is concerned. Case 636, the theory is that there is a mastermind in the killing of Senzo Meyiwa. And let me read this and then...
Why are you using the word remind as if I knew before?
Oh, let me withdraw reminding, what is a synonym of reminding, or to inform? To inform. I think it's a relevant synonym. Yes, to inform this. You are correct, Lordship. I should not have said remind you, as if you know. You know nothing about this. You're so impartial. The statement of the leading investigating officer read as follows.
We've already indicated that we're not sure what the nature of the current proceedings is, as if there are any issues, they need to be threshed out by way of affidavit. Now, my learned friend seeks to read out an affidavit of an investigating officer without that affidavit having been proved. Before you can put an affidavit on record, it must be proven. The person who compiled that affidavit must come and testify, identify that affidavit, authenticate it, and confirm it. Now it's just been read from the bar. We submit, my lord, that that would be highly improper. As the court earlier indicated, we were at the stage of the proceedings where the court had already ruled that the matter should be postponed so that Advocate Mshololo can get the opportunity to peruse the case docket 375 of 1 of 2019. Then Advocate therefore indicated that he would like to bring an application raising jurisdictional issues. And when we are about to agree on the timetable for the exchange of papers, today we've embarked on another process which, with the greatest of respect, my lord, tends to deviate from the normal procedure. We therefore request, my lord, that perhaps the current process be put to an end, as there's no provision, my lord, for this process. And in any case, Advocate Mshololo is currently busy with the cross-examination of the witness, which has now stood down for her to prepare further. If my learned friend wants to bring any other application, by all means, he can do that, but let it be done in a proper way, my lord.
My problem with what you say, Advocate Baloyi, you sit there for an hour or two, listen to that happening, and you hear me desperately trying to engage with what is ongoing. You don't say what you are saying now.
Yes.
The same with Advocate Mshololo. You sit there, and Advocate therefore thinks I'm taking sides.
Yes.
And that is why I sit back and listen, hoping that, and I say hoping because if I were a prosecutor, I would have done that. If I were a representative for accused number 5, I would have done that.
Yes.
Hoping that somebody will say the right thing.
Yes.
Now, after an hour or two, you are saying what you are saying.
Yes.
Much as I agree with what you are saying about laying the basis and so forth, I don't understand why it took until now
Yes.
for that to be raised.
Yes. My lord, we must keep in mind that each party gets the turn to speak. And Advocate therefore has now been given the opportunity to address the court. And my lord, it's now very difficult for us to interrupt him. We thought he was just going to make 1 or 2 quick points, but at this point, my lord, we we feel that the
But you are the one who handed
Yes.
Advocate
Yes.
therefore to me.
yes,
You said we
Yes.
were talking about postponement. We could not reach consensus. And because we could not reach consensus, Advocate therefore will take the court forward.
yes,
He did not do anything such for the past 2 hours. He did not. But you did not, I mean, now you are saying it, that this is not what he is supposed to be doing. I have been saying it painstakingly because if it comes from me, I'm taking sides.
The only reason, my lord, why we held back is because he said he's got new instructions that he wanted to put in record, and my lord, we allowed him that opportunity, but with the greatest of respect, my lord, we need to come to the point where we were when we adjourned yesterday, and that was to arrange a date, my lord, and we suggest that maybe at this point, my lord, we should now begin to make those arrangements for, for finding a
You
suitable
told me
date.
that you have not agreed.
Yes.
There's no consensus.
Yes.
And what I thought is that each will tell me where they stand,
Yes.
and then I make a ruling.
Yes.
Now he's even announcing that no ruling was made, no ruling was made. He's saying that repeated. Because when he spoke about everything else other than the issue of the postponement, you sat there and listened.
Yes. As we indicated, my lord, it was his turn to speak, but we submit, my lord, with the greatest of respect that he's had that opportunity, and we submit that at this point in time we need now to agree on a timetable to exchange papers as we agreed yesterday, my lord, and we therefore suggest, my lord, that we should now find, and I'm mindful of the fact that Advocate Tifo has indicated that he objects to the postponement, but the court has already indicated that it's inclined to grant the postponement. We suggest, my lord, that at this stage, that perhaps the three of us should again try and find common ground as far as dates are concerned for the exchange of papers. I think, as we indicated in the beginning, that's all that was supposed to have happened today, my lord, just to agree on a date for the exchange of papers and the date for the matter to be postponed. Advocate Tifo indicated yesterday that he will file his application regarding jurisdictional issues, and will then deal with his application as soon as we find the papers.
But he spent the last 2 hours addressing jurisdiction, and you said there.
Yes.
I did ask questions as he did that, because I was underlining the fact that it is now on issues of jurisdiction, and nobody said a thing between the two of you. And for me to have a repeat of yesterday, I didn't feel that I should be doing that, because you are there to guard against the interests of the state and to guard against the interests of accused number 5.
Yes.
Okay, no,
Yes,
I heard what
but-
you said.
Yes, but when counsel is on the floor, it's in terms of the procedure, and counsel is allowed to to address, and
The council is allowed. Once
Yes.
council is on the floor, we give respect. If I am
Yes.
fellow council, I give respect. But if it goes away from what we are doing,
yes.
we rise up and object.
Yes, and it's actually interrupting, which is a bit rude, but we just feel, my lord, that we just need to get to a point where we have to pick up from where we left off yesterday, my lord. God bless us.
As the court pleases, my lord. My lord, if my lord will recall from my last submissions that I made yesterday, I asked my lord that the matter be adjourned, and if there is any application that my learned friend will want to bring before this court, I will ask that such application be brought after I have finished with my cross-examination, my lord. Those were my last submissions yesterday, my lord. And after that, my learned friend started and brought the application on other issues unrelated to my cross-examination. And as such, my lord, and as Advocate Baloyi has just explained to this court, out of greatest respect to our learned friend, it is not because we did not see that we did not object because we did not see that it was wrong what was happening, but we thought maybe it will come to an end, my lord. My lord will recall that yesterday we stood this court proceeded up until the normal time, which is 3 o'clock.
No, beyond.
Beyond 3 o'clock, my lord. And it was really out of respect, my lord. And instead of arranging the dates yesterday for my application for the next remand, we had to entertain the dates to accommodate my learned friend's application, which was brought at a wrong time when I'm in the middle of cross-examination, my lord. I thought maybe a new precedent is being created, my lord. And this morning, under the name of new instructions, we sat down because we thought it's a proper instruction. And as we were listening to it, it was very difficult for us to stand up and say the instruction is not proper, my lord. Out of due respect to my learned friend, my
For
lord.
the whole 2 hours.
The whole 2 hours, my lord, we were just frustrated and traumatized here as to what is happening in this court. My lord, I'm saying this with due respect. We did not sit down because we did not know what to do. But out of respect, myself, my lord, out of respect, I said, let me respect my learned friend. Because it is my time, my lord, that I continue with the cross-examination. It is me, it is myself who had asked that these proceedings be adjourned. And now, my lord, in the middle of my cross-examinations, we are entertaining my learned friends addressing this court on issues that he should have discussed, he should have canvassed them at the time when he was given to do his cross-examination. This is very unfair, my lord, and it is unprecedented into our law that when a counsel for another accused is in the middle of cross-examination, another counsel will bring an application, whether it's on jurisdiction or whether it's on constitutional violation, my lord. But the 10, as the court has been repeating, that the 10 for my learned friend is coming, my lord. But at this time, he ought to have respected me and afforded me an opportunity to finish my cross-examination before he could bring the submissions he has made, my lord. And on that point, my lord, the fact that we have sat down and not objected to the submissions made, it does not necessarily mean that what has happened is right. It is wrong in law, it is unprocedural, whether objected or not objected, and it's inadmissible before this court. And it's a waste of time, my lord, at the time when I'm supposed to be dealing with critical issues pertaining to my cross-examination. My lord, I submit and I ask with due respect that these proceedings be stopped at this point in time, and then we adjourn the matter as I have asked this honorable court yesterday, that the proceedings should be adjourned to the date that will be suitable between ourselves and the role coordinator to allow the defense counsel, my lord, for accused number 5, that must be clear on record, to proceed with cross-examination.
Can I remind you also that before this round
Yes,
of
ma'am.
proceedings, we were all concerned
Yes, ma'am.
about speedily finalizing this case.
Yes, my lord.
I took it upon myself to approach the DJP,
Yes, my lord.
who told me that he will contact the role planner.
Yes, my lord.
And he told me that there is possibility to devote the whole of the next term,
Yes, my
the
lord.
third term, which would have been from July up until the end of September, and even further
Yes, my lord.
if we would have agreed.
Yes, my lord.
And we agreed that we should, no, we didn't agree. It was suggested that we should hold a meeting.
Yes, my lord, I remember.
This case was not running.
Yes.
It implied that people should come. Then we went to say that even a virtual meeting,
Yes.
including the role planner and the DJP and all who may be necessary,
Yes, my lord.
should then participate so that we can strive to devote the entire third term, which would have been 3 months,
Yes, my lord.
to this case.
Yes, my lord.
And that meeting did not happen. I was told on the morning of the day agreed to be the day on which to try and capture the third term for purposes of this case, I was told that Advocate therefore says he will not be part of it.
Yes, my lord, I do remember very well, my lord, that myself and the State Council were available, my lord, to attend that meeting, my lord. And from the first meeting, we were able to zoom in the virtual meeting. However, it did not, we did not finalize it because my learned friend, Advocate, therefore, left that meeting, my lord. And then it was rescheduled for the second time, wherein the DJP was also going to be involved. And we received information, my lord, that Advocate, therefore, and his instructing attorney were not willing to enter, to attend that meeting, my lord. As a result, we could not finalize the next date, my lord. And from yesterday, my lord, I have been indicating to the State Council to say, I am available at any time should there be a need to bring this matter forward, either in July or in August. I am amenable to any dates that, according to the coordinator, can be allocated to us.
But the reality is that barring a miracle, when you have dates and you don't take them,
Yes,
the way
ma'am.
things run in this division, those dates get given to other pressing cases, which has happened. I don't know whether approaching the powers that be may still salvage anything, but the reality is that those dates have gone. They've been given to other cases.
I agree, my lord, but the reason why we could not finish that meeting, it is not because of my fault, it is not because of the fault of the State Council. It is Advocate, therefore, who exercised his rights not to attend that meeting, my lord. As a result, we did not conclude anything regarding the end blocking the dates. And right now we are sitting, yesterday we were also trying to liaise with the role coordinator. He was also not available to cooperate with us regarding the arrangements of the dates. Hence, Mr. Baloyi addressed his lordship this morning to say we were unable to reach a conclusion regarding the next remand date, my lord. That is where we are sitting at right now. And then lastly, before I finish my submissions, my lord, what is the defense counsel for accused number 1 to 4 is trying to do now? Trying to lead and introduce the statement of a witness who is not in the witness box is wrong in procedure, my lord. There is a way in which the statement is proved in a criminal law. And it is going to prejudice the same witness when he comes to testify, my lord, if his statement is read into the record when he is not here. My lord, I thought we all know the criminal procedure. That is why I sat down, my lord, not because I did not know what to do or what to say, my lord. It is wrong in law, it is wrong in procedure, and it is unfair to the state case, my lord. Those are my submissions, my lord. And I humbly ask, my lord, that we now adjourn this court to the next proposed date, wherein I will be given an opportunity to proceed with my cross-examination, my lord, as the court pleases, my lord.
This is my lordship. It should be clear, your lordship, that according to what utterances I've heard between Baloyi and Mshololo, that accused number 1 to 4, they don't have the rights, and they must be excluded from these proceedings. And if that is the way, that will happen. And I cannot. I've heard Mshololo last week on Wednesday. He said, there's no counsel who can tell me what to do and what not to do. That attitude, that conduct, is that the conduct of the counsel who is respect her fellow counsels? If the word of Mshololo is the alpha and omega in this court, then there won't be necessary for me to, for the rights of accused 1 to 4 to be fought for. They've got the constitutional rights.
Let me finish that. All I'm saying is that we could have had the whole of the next term but for this attitude where I cannot be involved in the fights in between council. I cannot be.
Definitely so.
You should fight it on your own. If anybody goes overboard, you know where to go.
Exactly.
But where we allow attitude to deny trial time of accused persons who are in custody, and we come before court and we speak about rights when we have just frustrated them from 3 months of proceedings, it is not right. It is not right, and it is not straightforward.
It is not right.
Yeah.
Yes. And I wouldn't know.
So
by whose-
now I want dates. I have told you repeatedly, I don't know what we were busy for the past 2 hours. We want dates for the next round for this case, so that for God's sake, these people can face their witnesses who come and accuse them, and they defend themselves, and the court makes a decision. That is what courts are for. And this process that you speak about, which seemed very flawed, very wrong within the police and the prosecution, find a good time, which is not now, to raise that.
The reason, Your Lordship, as I've said to this court, I said, we humbly make this submission as per the request of my attorney that we are making this submission on the basis of the fact that there is no judgment or there's no ruling made on the basis of the contemplated postponement request by Mshololo.
But we were doing it at the wrong time, because it was not even time to speak that. This is the time when we have to be looking for new dates, because whatever we do, this case won't be finished this week.
That is the reason that we don't, from the side of the accused 1 to 4, we are not even trying to think we should contemplate on talking about the dates of 3 months. Well, this when the accused will be in the custody.
But we are making sure, we are making dead sure that they remain in custody longer than shorter. You are every 10 of the way, you are making sure that when there's efforts to try and loosen the system and allow the situation for this trial to unfold, you have decided that they must not be tried. And that's not a call for you. The DPP has decided that they should be tried. You have decided, I don't know where, that they must not be tried. I have never heard of it. It is never done that way. It is never if the state comes with a dead case and tries to prosecute people, the defense counsel, fortunately there is 1 year, if there was not, legal aid would come into the fray to check everything, and if a wrong decision is arrived at by the court, the process is further. This is not the be-all and end-all. There are other courts above this court. That is how we operate in courts.
Exactly.
Not to sit, and I want to repeat, and not to sit in court and adopt a normasia attitude. It doesn't work that way. It doesn't work that way. We go to the procedures. They are laid out. They are in books and they are in journals that you can research and find out. But when we want to proceed in court, let us proceed in court. Whoever holds his fort and decides things are going to work out my way, whether it's the judge, whether it's the defense counsel, even the interpreter, they cannot hold that as ransom and get away with it. There's a further process.
Your Lordship, as we say, Your Lordship, and the Holy Book says, you see the stick in your brother's eye, well, there's a block in your eye. This is what is happening with the DPP. He's the last person they can talk about the procedure, Baloyi. There's a corruption happening in the office of DPP. Why we have the 2 dockets today?
Which means
it's a problem.
You have many points for appeal. If the wrong decision is taken, you have so many. You are not wanting. And
I have
And
so many.
in the way things happen here, even if it's very unfair, the procedure binds us to hold back and wait for the right time. If we are practicing law, unless we are practicing something else.
I've heard that my learned colleague, in particular, Msholole, has been so sarcastic. One can be sarcastic as much as she wants. I'm not interested in that, sarcasm. I'm interested in fighting the constitutional rights of my client, 1 to 4, in this court. Because they are before this court unprocedurally. So it cannot be today that Advocate Waloi will say to me,
Are you not
whose
frustrating those
judgment?
very rights? Because
This is what I see it happening in
If
the
I
court.
were you, I would go and fight it, knowing that mistakes are being made along the way. Even the judge is taking sides. When time comes, I bring all those points into an appeal, and that's how the law works out in this country under this constitution.
And I don't mind to be taught the law, Your Lordship. I'm very much keen to learn myself. I love so much to learn anytime. But I cannot be learned by the person who themselves are not learned. These two people on my left and right are not learned. They think they can tell me. Wait.
Lordship, may I please intervene?
Your Lordship.
May we approach our clients, please? We request to approach the clients, Your Lordship. Can we approach the clients?
Not only to approach it, can we stand down? Maybe 15 minutes.
No, it's lunchtime now.
15
I want
minutes.
to approach my clients.
No.
May we approach the clients, my Lordship, please? Please, not all like that.
to interrupt the court. I think maybe, is it not the correct time to take a long adjournment, my lord, to allow my learned friend to continue with the consultation?
Mr. Tobani, you seem, I'm not calling you back, I'm saying you seem to need more time.
Yes, my lordship, we may adjourn for lunch.
Yes.
That's a copy, please, my lord. After we consulted, my lord, with our clients, the instruction that may I proceed to address the court.
Yeah.
The reason of today why we asked the court that we address with regard to the postponement is because the court has not yet announced or made a judgment whether the postponement will be granted or not. Hence, we were raising the issues of those two statement letters C1 and C2. Which are the basis for us to oppose postponement, and will respect the decision of the court after we make our submissions. Your Lordship, if 375 doesn't have merits, I don't see a need for a postponement because it doesn't have merits. It won't assist. And the counsel for accused number 5 did read the statement, the letters on record, and she said she's happy with the letters. However, we have our own reservations. Hence, we oppose postponement. Exhibit C1. Dated 8/6/2022. And Exhibit C2. Dated 13/6/2022. When we look at the signatures, we have doubts that they are from the same person.
But then, Mr. Shivani, is that not the issue about which we said heads should be submitted so that this court can deal with the issues? Because if you rise and say this about that docket and somebody else rises and says something in the manner in which we are going, it doesn't assist. Even the decision in terms of the ruling that I'll arrive at will not have been enriched by the submissions that have been properly made.
As a court,
I do not understand why there is a shift away from an approach like in any other process where heads are submitted, the other people are given an opportunity to submit heads in response, and then the court sits down and looks at everything.
Your Lordship, I will withdraw that submission based on the court advice. Your Lordship, the court need to look at Section 35D of the Constitution. It's clear that the trial must be concluded without unreasonable delay. Postponement to read and consult on a docket which doesn't have merits, it is unreasonable. Where is it taking us to? To nowhere. We therefore pray that the postponement not be granted and Mr. Messiah be called tomorrow to come and stand, back to the stand and testify. Moreover, Your Lordship, the court may also look at the famous Section 342, capital letter A of the Criminal Procedure Act. The reason why we submit that the rights of accused 1 to 4 will be violated, more in particular, 1 and 2. Because when they were arrested, they were not serving any sentence. But accused 5 is serving 6 life sentences plus 39 years. It will not help. It will not help the Honorable Court.
Mr. Towani,
Thank you, my lord.
you know that the practice that obtains in our system is that a court is not supposed to know about criminal activities or negative aspects of an accused that stands before it. I think the legislature went that way in order to avoid an undue influence. That is why even in cross-examining, we always warn practitioners not to open that up, not to try and lead character evidence. But now here boldly, you are pinning acts of criminality on a co-accused, different from the people you are representing.
Your Lordship, even though I agree with the court, but we are only dealing with postponement. I do agree with the court that it can tantamount to character evidence. However, if the court insists that we must not go there, we still submit that.
Yeah, I interjected. I think Advocate Mshololo was on the brink of saying something. I don't know whether it's along the lines where I was addressing Mr. Towani.
My apologies, my lord, for interrupting the court, my lord. I stood on objection, my lord, to the submissions that are being made by my learned friend now, my lord. Right now, the only issue that we need to deal with, my lord, is to arrange the date for the postponement, as I have asked before this court that the matter be adjourned. And I object to any further submissions to be made before this court not related to the postponement.
If the submissions are to counter your submission towards postponement?
My lord, the issue of the accused who are being in custody, my lord, cannot be dealt with at this stage when I'm busy cross-examining my witness on behalf of my client, my lord.
Yeah, that point I take.
Yes, my
But the issue of opposition to postponement?
of opposition that can be entertained, my lord. Thank you.
As the court pleases, Your Lordship, that's what we are doing. We are opposing postponement. And postponement, which is supported by reasons, which we have already submitted to the court. I don't want to have to repeat them. Hence, I even said there was no order whether we are postponing or we are not postponing. Lastly, our prayer is that postponement not be granted. Based on the reasons I already alluded, I don't want to repeat myself. And the witness who's before the court in the stand must be brought back, if possible, tomorrow, so that his testimony can be finalized. Thank you, Your Lordship.
Advocate Baloy?
As the court, please, my lord. We've already indicated what our standpoint is last week, Thursday, and yesterday as well. And we haven't deviated from that, my lord. We've got nothing further to add, my lord.
At this time, the court is dealing with the aspect of an opposition to a request for postponement. The background being that in the case we are busy with 636, case number 636, it has now been admitted even by the first state witness for the state and the state that there are two dockets of existing and that the matter with which we are busy pertains to the first docket. I don't want to get into the details, they will not assist much, save to say that the state and the legal representatives of accused number 1 to 4 became aware of this docket well before Advocate Mshololo, who only became aware or who received confirmation of it last week, and which is when it was also discovered to her. The court had sight of a copy of that docket. It cannot be described as thin. I do not know what is in it. However, Advocate Mshololo indicated that she needs to go and study that docket. She also hinted that she cannot rule out a possibility of a need to consult her client further, depending on what she will find out when she goes through the second docket. Mr. Tobane indicates that the fact that the state has a position to the effect that the contents of the second dockets are not material. According to the state, it is as good as not existing. And Mr. Tobane says because of that, that docket should be viewed to be of no consequence, and therefore it should be the case that Advocate Mshololo does not need the second docket or knowledge of the second docket or its contents in order to continue with cross-examination. What is worrisome is that a legal representative or legal representatives of one set of accused persons in a case is telling court that a strategy thought up by a legal representative of another, not only another, different accused as opposed to the accused they are representing, they view that as unnecessary. Like I said, I do not know what is in the dockets. I'm not even supposed to know. And the Advocate Mshololo told court that what she wants to do is part of a preparation of the defense. She even leveled blame upon the state, and I need not go and revisit the response of the state. Safe to say that Advocate Baloi told court that he too only had the benefit of a discovery of that second docket at a much later stage, and he struggled for some time in order to be able to lay hands on a copy of such a docket. At the root of everything else, like most of the people in this case have been saying, is the right of accused persons in trials, the constitutional rights. At the helm of everything, we know the accused are entitled to fair trial. And aligned to that, accused persons are also entitled to speedy trial. Put differently, they are entitled to be submitted to trials that are not unnecessarily delayed. The fact put on the table by Advocate Mshololo is that she needs to go into the contents of the second docket. I don't know if she has started. I would have expected her to already have started. And she needs that in order to prepare the defense of her client. The reality of the court is that denial of that opportunity will clearly result in lack of an opportunity on the part of Advocate Mshololo to prepare the defense of her client. On the other hand, giving the wish of the legal representatives of accused number 1 to 4 will avert a situation which may result in a lengthy trial. Therefore, it means that the court has to compare between two sets of rights. The rights of accused number 5 to a fair trial by way of giving leeway for his legal representative to prepare appropriately within a reasonable time, and on the other hand, the rights of accused number 1 to 4 to a speedy trial. In order to be able to decide around that, the court compared the two sets of rights. If the rights of accused number 5 get undermined, the whole of the trial he is undergoing will be tainted. If the rights of accused number 1 to 4 are undermined by way of granting a postponement, their rights also to fair trial and to a speedy finalization of a case shall be affected. The rights of accused number 5 will be affected holistically. The rights of accused number 1 to 4 stand to be affected insofar as it regards 2 days in this trial. I speak as I do because in any case there would be a need to seek postponement on next coming Friday. And I must repeat the background I gave earlier. There was leeway, right open, for this case to proceed next term over 3 months. And because of the background I gave, where one of the legal representatives was reluctant to be in a meeting to arrange that, that has been lost. We have lost 3 months, and now, deservedly and rightly so, there is a complaint about 2 days that may be lost, which is Thursday and Friday. When I compare what accused number 5 may have to forego if a ruling doesn't go his way, with what accused number 1 to 4 may have to forego if the ruling doesn't go their way, I feel that there is more weight on the part of the rights of accused number 5. And therefore, given that scenario, the court grants the application for postponement. I did request the parties before to try and find consensus around the dates. I do not know whether on leaving court or upon adjournment they ever attended, but what I perceive as I sit here is that the state and the representative of accused number 5 are ad idem in terms of agreement to a postponement. As we sit here without choice because of the opportunity lost, we only have September as the earliest time to which this matter can be postponed. I did say also this morning that for me, efforts should go forward in terms of trying to bring the trial earlier. And even if those efforts do not succeed, my thinking is that beyond September this year, the parties will be encouraged to try and secure an en bloc placement of this matter on the roll. It remains to be seen whether the impediments that saw us losing the entire third term for purposes of this case will replay and therefore frustrate once more the endeavor to secure an en bloc placement on the roll of this matter. Having said all that, the ruling is that the application for postponement is granted. And having said that, again, we should not lose sight of the fact that the legal representatives of accused number 1 to 4 have issues around dockets, the 2 dockets. And before we agreed to meet today to finalize dates, we had mooted issues of a process in which Advocate Tefo, on behalf of accused number 1 to 4, is expected to furnish heads of argument around the aspect of 2 dockets, which also hinges on a very vital aspect of the jurisdiction of this court. Yesterday, we had a presentation of on jurisdiction, on issues of the transference of dockets, if not cases, from one jurisdiction to another. That has not been presented within heads of argument, and that has not seen an opportunity where there are responses from the state and Advocate Mshololo. And it is my view that we do not wait until September. It is my view that we find a date within recess where the parties will have submitted heads, and where on that day they shall be before court to argue based on the heads, and the court shall make a ruling way before September. That is entirely dependent on what Advocate therefore does. If heads come, it is my view that both Advocate Mshololo and Advocate Baloi be ready to respond within 5 days of receiving those heads. And if there are certain impediments, that the parties notify each other among themselves, much as whoever has that impediment should make an effort for the court to be notified that the 5 days cannot be complied with for the one or the other reason. If that happens, on the day I am suggesting, which should be over recess, and I'm saying recess knowing that recess is the time to go and rest, but the agency that is being sounded by everyone has come to a point where everyone who sounded it has to put that agency in their own personal action around this case. And that is when we will see the genuineness of the agency that is being sounded by acting in line with the sentiment of agency that is being sounded. Having said that, we need to find that day over recess, because I'm saying we need to find that day because over recess there are issues of recess duty that the court may be seized with. There are issues of other work-related commitments that are in place, but fortunately they do not consume a majority of the days over recess, and therefore the court has time available depending on the inclination of the parties to be available for that argument. The earlier that date can be within recess, the greater the possibility that by the time recess ends, there shall be a ruling in place, and those who need to respond to that ruling will have time to do so. So the long and the short is that the application by Advocate Mshololo for postponement is granted. The date of postponement is not determined by now because the parties have to engage each other and agree. If they do not, then the court might direct in terms of the date of postponement. And we should also know that this date of postponement is so as to deal with somebody has called it a conundrum, to deal with the so-called conundrum of 2 dockets with 1 deceased person and 2 sets of investigators, and possibly 2 courts in 1 division, in 2 cities in that division. So that is my ruling. Postponement granted, a date to be set for argument regarding the issue of the 2 dockets. And therefore, when we argue, when argument is heard on the issue of the 2 dockets, that is when we are going to visit further the aspect. We know that September is a date in place. I still urge that efforts be done to see if no miracle can come to give leeway for the next term, if not part of it, to be devoted to this case. That is my ruling.
As the court pleases, my lord.
Mfethu-ke isinqumo senkantolo ukuthi emuva kokuthi ihlanganise konke noma ibheke-ke inhlangothi zombili-ke kwizethulo ezenziwe la enkantolo, ukuthi-ke iyanikeza-ke kwisicelo esenziwe uyena-ke ummeli wammangalelwa wesihlanu ukuthi ecela isikhathi esanele ukuthi ahambe ayoyilungiselela-ke ngalelo dokodo lesibili elivelile futhi-ke ebengalazi yena-ke. Inkantolo ekubhekile-ke ibheke ukuthi-ke kunalamalanga amabili-ke acelwa ummeli wakhe ummangalelwa wokuqala kuyokusho ummangalelwa wesine, bona-ke bathi-ke akabizwe ufakazi lamalanga amabili asele. Iphinde inkantolo ibheke-ke nokuthi besikhona-ke isikhathi esanele seyinyanga ezintathu ebezitholakala ukuthi icala lingaqhubeka-ke liqhule, kodwa-ke akwenzekanga lokho ngokuthi omunye wabameli-ke noma ummeli wabamangalelwa laba bane-ke akavumanga-ke nkathi wayebizelwa emhlanganweni. Uma-ke inkantolo isibheka-ke inhlangothi zombili ifikele kwisinqumo sokuthi-ke ayinikezele kwisicelo sakhe ummeli kamangalelwa wesihlanu ukuthi icala-ke alihlehliswe, futhi-ke likhona nelanga elizobhekwa-ke ngaphambilini koSeptember la khona-ke bazohlangana khona bonke abameli balethe izethulo zabo ngalokho-ke noma ngodaba-ke noma oluvezwe uyena ummeli wabamangalelwa laba abane abamele. Kodwa-ke isinqumo senkantolo ukuthi icala iyavuma ukuthi alihlehliswe ngenxa yesicelo esenziwe ummeli kamangalelwa wesihlanu.
There was a date that was communicated yesterday, which is the 5th to the 16th of September. We were also given another date that we can block, that is the 4th to the 14th of November. We will block those 2 periods, my lord, for the continuation of the proceedings, if the date is suitable to my colleagues.
Oh, so something that was not dealt with specifically is that we spoke of 5 days for Advocate therefore to prepare heads, and we also initially he had given himself 3 days. The order shall be around 5 days for that to happen, and the other parties are given up to 5 days. If any of the parties can cut this period of time to a lesser period, it will not do any harm but demonstrate the sense of agency such a party is views to be attendant to the matter.
The court pleases. The court pleases, my lord, before this matter is adjourned, I just have two requests that I need to submit before this court, my lord, before we adjourn the matter.
Yes, but then the date that we are going to, I had thought there shall be an interaction between the parties. If any of the parties feel that they can cut the 5 days I have pronounced to a shorter period, so that you come back and inform me, so that the date of argument around the heads be earlier rather than later.
My lord, I can make an undertaking on my behalf to say I will be able to file my heads 5 days upon receiving the heads of the respondent for accused number 1 to 4.
Advocate Baloy,
This in order, my lord, to also be able to file our heads within the 5-day period.
and those, when are those 5 days starting? Are they starting from the start of recess, or are they starting from today?
I think they're starting from today, my lord, but maybe my learned friend can address the court regarding that.
Advocate Tefo?
Considering the holiday of the 16th June, will start on the 17th, Friday.
That will be Friday, Monday, Tuesday, Wednesday, Thursday. What date will that Thursday be?
That will be the 23rd, my lord, 23rd of June.
And the 5 days from there?
5 days from the 23rd, my lord, will be the 30th of June for myself and the State Council to file our heads, my lord. As the court pleases.
And date for argument on the heads? You will understand this is what the parties should have been able to do on their own.
I think that's wherein we encountered some problems, my lord, when we were discussing that
Let's
yesterday.
not go back there. Let's determine when that can happen.
My lord, maybe we can look at 5 days from the 30th of June.
What date shall that be?
It will be the 7th of July, my lord.
It is not convenient for me. There will be something work related.
On that day.
7th, 8th to the 8th, I think.
8th is a Friday, my lord.
Yeah, 7th to the 8th, I think I will be engaged.
Okay. Then with the next available date, my lord, it's the Monday, the 11th of July.
Is that okay with everyone?
This in order, my lord.
It's suitable, my lord. 12.
I think if the date turns out to be problematic, we can always communicate, my lord, to to determine a more suitable date. But at this moment, it's in order.
The logical date, therefore, for postponement of this case is the 12th.
The provisional date is the 12th in order to hear this interlocutory application, my lord, if I may put it like that.
Yeah.
But then the next remand date for the main trial now, it's the 4th of September, my lord.
Yes.
Yes.
Advocate Baloy?
The date is the 5th of September.
Okay, no. I'm saying, do you agree that therefore we are agreeing by implication that on the 12th of July we shall be here for argument?
Yes, indeed. Barring, of course, any any emergencies, in which case the parties can communicate among themselves. But absent any emergencies, we can settle for the date, my lord.
Advocate, therefore, the 12th. Are you in agreement?
The court doesn't need my confirmation, Your Lordship. Can proceed.
By agreement, sorry.
But the other related issue is the presence of the accused on the day.
Oh, yes.
We might need. In fact, they have to be present, my lord. We thought
I was almost thinking aloud, saying, could it be that we want to talk about them without them?
Yes.
But I think the best people to guide us are the legal representatives.
Yes. We explore the possibility of video conferencing, but some detention facilities don't have those facilities. And the other problem is the issue of an interpreter. So it would appear that the best solution is for them to be present here at court. In which case, we suggest, my lord, that then the accused also, that an order be made that they be brought to court on the day, my lord.
Yes.
On the J7.
Ordinarily, I think
on the
a
J7s.
postponement like this implies that they will be here. unless I'm missing something.
Yes.
That as we postpone this case to this date, the expectation is that on that date they will be brought to court.
As long as the J7s are endorsed to that effect,
Yes.
that shouldn't be a problem.
Yes.
Yes, please, the court will accept. It's confirmed. They have to be here.
I confirm, my lord, they have to be present in court. My lord, can I then now make my request before we adjourn the matter, my lord?
Oh, yes. Oh,
Thank
sorry, I nearly forgot. Yes.
My lord, in order for me to enable my lord, to prepare further, I have the following request that I need to place on record, my lord. The first one, my lord.
Wait, so
also-
that I record. Yes.
The first one, my lord, is that as I will be reading the second docket, case 375, I also need a clarification, my lord, in respect of Exhibit C1, which is a letter from the DPP regarding the second docket.
Will that not have been dealt with within the heads?
Within
What-
the head?
yes.
No, my lord, heads are not part of my preparation for cross-examination, my lord.
Okay.
Yes, yes. I'll be preparing on the new evidence that I've just received, my lord.
Okay.
So, my lord, I am asking and for an order directing the DPP South Gauteng to give clarity, my lord, since Exhibit C1 refers to a junior who has made an opinion. C1, my lord,
Yes.
refers to a junior who has made an opinion. Then now the DPP South Gauteng is the head of the office now. Then he must give clarity on the decision, if there is any, that has been made under the case, docket case 375, my lord. Because, my lord, I see that if it's referring to the junior, it means there is someone superior who has to make a final decision. And in case of the, in respect of this letter, it is the DPP himself. The reason why, my lord, I'm seeking for that clarity regarding a final decision under the case docket 275/01/2019, it's because when we come back in the main trial, my lord, I want to know the status of the people mentioned in Exhibit C, my lord, whether they will be coming to testify as suspect witness or as accused witness, whichever way as the Director of Public Prosecution directs the status. The Exhibit D is before this court, my lord, and we need to deal with it, my lord. And the name of those witnesses whose status needs to be clarified by the DPP South Gauteng appears, my lord, on page 5, my lord, of Exhibit C. And those names, my lord, are Longwe Twala.
Wait.
Sorry, my lord.
Longwe Twala,
Longwe Twala, Kelly Kumalo, Gladness Kumalo, Zandi Kumalo.
wait.
Sorry, my lord.
Yes?
Zandi Kumalo, my lord, did you get that one?
Yes.
Thank you. Tumelo Madlala. Mthokozisi Twala. Meki Phiri. So the clarity that is sought from the DPP South Gauteng, my lord, will clarify the status of this witness, and as I'll be preparing to know whether they are the witnesses in this case, or they are the suspect witnesses, or they are accused witnesses in preparation of the trial, my lord. And my lord, it will assist this court if we get this clarity from the Director of Public Prosecution South Gauteng himself. If he confirms whether the case, whether the decision has been made under, a final decision has been made under Phosphorus Case 375/01/2019, whether to decline to prosecute these people, or whether the matter is still being investigated, or whether this docket will be combined or is combined with the docket that we are dealing with before this court. We ought to have received this clarification, my lord, from the DPPs themselves. However, seeing that I need clarity in order to be able to finalize my preparation, that is why, my lord, I am involving and asking this honorable court to make an order to that effect, directing the DPP South Gauteng to give his stand on the status of this case, my lord. My lord, that's my request. And then the second request, my lord, yesterday my learned friend, counsel for the state, made submissions, my lord, to say there is no one who can say he was not aware of this docket. And he made, my lord, a reference to say, I made submissions before this court to say I am aware of the police docket Phosphorus 375. Therefore, my lord, I'm asking for an order to get a transcript record for that day, wherein my learned friend will be able to refer this court to the page and paragraph wherein I made those submissions. Can the interpretation be done, my lord?
Just waiting for you to finish.
I've finished.
Mangalelo behlanu ke okwenzekayo noma izicelo ezenziwa ummeli wakho la enkantolo noma unesicelo ke asenzayo esizomsiza ke ekuthini ke ayilungiselele nanjengoba sizobuya ngalelanga enkantolo ezolisho ukuthi nanjengoba ezobe efunda ke leli docket ke eli 375 ehambisana futhi nencwadi ke ebuyile eSouth Gauteng ukuthi ke ucela inkantolo ke ukuthi iyalele bona ke eSouth Gauteng noma ke owengamele ke ezokushushiswa khona lapho nanjengoba beshilo ukuthi kwakuwuvo lweadvocate eyijunior ke lolo noma njengoba bephendulile kule yancwadi bacela ke ukuthi yena ke uDPP noma ke ongaphezulu kuyena ke ngesikhundla noma isenior yakhe ke kube uyena ke ozothi achazele noma acacisele lenkantolo ukuthi ngabe sesithathiwe yini isinqumo mayela naleli dokodo eli-37501/2019 nokuthi labantu laba abashiwo noma amagama abo ke achaziwe ku page 5 wakhe uexhibit C ekuyilabo abalandelayo uLongwe Thwala, uKelly Khumalo, uGladness Khumalo, uZandile Khumalo, uTumelo Madlala, uMthokozisi Thwala kanye noMeggy Phiri ukuthi uma ngaba beza enkantolo beza bewofakazi beza beabasolwa yini na ufuna nje ukuthi ke lokho kucace ngaphambilini kokuthi kufika ilanga ekuzoqhubeka ngalo ukuthi abuze ufakazi imibuzo mayelana nalelo dokodo lelo futhi ke lokho ke kuzosiza lenkantolo ke ukuthi leso siqinisekiso leso singatholakala kuyena ke lo wengamele zokushushisa eSouth Gauteng amagama ke singaphumi la leso sinqumo ePitoli nokuthi futhi lelo dokodo lelo ingaba idokodo elihambelayo lona lodwa noma lihlanganisiwe yini naleli leli eliphambi kwenkantolo eli-636 okunye futhi ke ocela ummeli ukuthi ke nanjengoba umshushisi eshilo izolo uma ngabe ekhuluma ke ukuthi ummeli kaMangalelo wesihlanu la ziwu-22 ka-April 2022 noma kuwona lo nyaka lona ke washo enkantolo ukuthi ke uyazi noma wayazi ngalelo dokodo lesibini ucela ke ummeli ukuthi lokho noma kuyiweke kulokho kwenzeka ngaleli yalanga ucele laba ke abarekhodayo ukuthi ke bakhiphe leyo ngxenye leyo la asho khona ke ummeli ka number 5 ukuthi ngempela wayenolwazi lwalo leli dokodo.
My Lord, I will then ask that clarity be given during the period of adjournment so that I'll be able to prepare, my Lord. Although I cannot direct to say after how many days, but during the period of adjournment, my Lord, if I can be finished with that further particular, my Lord.
Advocate Baloyi.
Thank you, my Lord.
As a court, please, my lord, the state has got no problem with the second request, but as far as the first request is concerned, my lord, to direct the DPP to exercise a prosecutorial discretion, I think, my lord, we should leave it to the DPP. I undertake from my side to make sure that that is done, but I don't think it would be proper to compel a DPP to take a decision. I don't think it's necessary, my lord, to make that order. We will make sure that that decision is taken and communicated to Advocate Mshololo.
Mayiphendula ke mshushuthi akasiboni ke isidingo sokuthi inkantolo iphoqe noma ke abengamele zokushushisa eSouth Gauteng ukuthi bathathe ke isinqumo kodwa yena ke ngako lakho uhlangothi uzosenza ke isiqinisekiso sokuthi isinqumo siyathathwa ke kodwa ke akaboni ukuthi inkantolo ifanele kuba yiyona ke ephoqayo.
My Lord, it is in the interest of justice, my Lord, that a clarity is sought from the head, so-called, my Lord.
Are we not ahead of ourselves? Because do we not require, because whatever we say,
Yes, my Lord.
that person will not be responding here.
As the court
I think
president.
your point has been made.
Yes, my Lord.
You didn't just make a naked demand. You made your request
Yes, my
and
Lord.
you substantiated.
Yes, my Lord.
And Advocate Baloyi is here,
Yes, my Lord.
and we expect him to relay that.
Yes, my Lord.
The only thing I would request Advocate Baloyi is that the response of the DPP be speedily communicated, and I would think, so that I know where I stand. I do not want scorpions emerging from holes around me, that the response of the DPP through the secretary be communicated to me, so that I be aware of what is happening.
As the court pleases, today is the 14th. We will try and facilitate that at least by the end of the month, my lord, at the latest.
As the court pleases. My lord, those were my submissions, my lord. Thank you.
As the court pleases, Your Lordship. May I address the court? It's in relation to the new instruction as per the watching brief on 375,
Yes.
whereby the new instruction is that based on the paragraph 3 of exhibit C1, in this regard, no, C2. C2 is the one that is talking about 375, whereby it stated that
You said exhibit?
C2,
Yes.
where the subject is about 375.
Yes.
Yeah, the instruction is that in relation to paragraph 3 of mention of no merits. Therefore, my instruction is that the DPP should issue the nolla prosequi certificate so that my client will take it from there. So
Yeah,
we
can
accept.
you remind me, by the way, when is a nolle prosequi certificate issued? My sense is that it is, a case gets reported, statements get gathered, the docket is regarded as completed or complete by the DPP or by the investigator who submits it to the DPP, who reads it and then makes a decision.
When the DPP has the reason to not prosecute
Yes.
or prosecute,
Yeah.
that is the time.
So, yeah,
So-
but remember, I'm speaking about a sequence. Are you saying that in this case,
In this regard,
that sequence has already evolved? All that needs is a decision.
definitely from the day one when the decision was made on 636, it was clear that the decision will not be made on 375. It has been confirmed in terms of exhibit C2. So furthermore, to the experience or the reason that we are here in terms of the 636, my learned colleague Advocate Baloi, during the indictment or engagement, when the provision of section 6B of the CPA was done to the NDPP, the response in paragraph 3 was that the DPP has decided to prosecute 636, and then on failing to have conviction on 636, it will then consider to prosecute on 375. That is the answer. So hence we are saying that since well the decision has been made on 636, we cannot make to be wait when this matter, since well today this matter has been prolonged by the postponement. My client humbly requests that, it's the right. It's the right of the complainant to have the decision from the DPP. So hence this request, Your Lordship, and that could be made within 7 court days. Thank you.
Advocate,
As the court pleases, I think the request of Advocate Nshololo and Advocate Tifo are 1/6 of the one and half dozen of the other. Because if a decision is communicated, then it will inform the request of Advocate Tifo. If the final decision is to decline to prosecute, then the request of Advocate Tifo will then kick in.
yeah.
And
But I think I cannot differ with you, but you seem to be not on the same tempo.
yes.
I think Advocate Tefo, what the Advocate Tefo is looking at is something that should unfold sooner. Because there is talk here of waiting for this trial to run with the reservation of a possibility that the other docket may run. But he seems to be saying, as of now, he requests a decision to be in place by the DPP, and if that decision is not to prosecute, that a nolle prosecute certificate
Yes.
be issued. We know that a nolle prosecute certificate opens leeway for those concerned to be able to take other measures.
Indeed, my lord, as I'm saying that the request of Advocate Nshololo means that the DPP must take a decision, and depending on that final decision, then the request of Advocate Tifo will then come into the picture, depending on what the decision is.
Your Lordship, you were correct to say the requests are not the same. The accused 5 saying we need to know the reason. As for the people mentioned in Exhibit C, which is for 375, are they going to be the witnesses of the state?
Is that not
For what?
what Michelle
Yes.
Yeah.
So actually is what the accused 5 is expecting or demanding meticulous reasons as to the characters in 375 as informed by the Exhibit C. And then my instruction is so far as I am watching brief of the Meyiwa family. It is clear it's a common cause, and it has been confirmed as from yesterday by paragraph 3 of Exhibit C2 that junior state advocate, that is the opinion of a junior state advocate, which are without a merit. So the reason we're here, because we talk about the same incident that happened on the same address that we all know now, but the docket are different. So now we are saying, for the basis, for the, in the best interest of my client as a watching brief, we are humble, even though it's the responsibility of the DPP to make a decision, to inform. Anyone in this country who is a complainant has got the right to know what the decision that was taken by the DPP is in that sense. And the DPP can say, I prosecute or I don't prosecute, and may not even give the reason. So what we need, we are not demanding the reason from DPP. We are requesting what is rightful ours, that information, to say, let us know, inform us officially that you did not prosecute, so that we can also have the right.
Advocate Baloyi, the length of this current discussion, in my understanding, is due to the fact that you went some way answering on behalf of the DPP. The request is made. My sense was that you would convey the
Yes,
the
indeed, my
request.
lord. Yes.
And because there wouldn't be a need for any discussion. It's a request to be conveyed. The person concerned shall respond.
Yes.
And then when that person responds, it shall be up to advocate therefore to see whether there's anything to take forward.
Indeed, my lord.
Okay.
I'm sorry to intervene, Your Lordship. Actually, the response was not in relation to the DPP. The response was in relation to the provision of Section 6B of the CPA, which is only the NDPP who can make a decision. So the NDPP did not make any decision. She deferred what could have been her decision to Advocate Waloyi, and he responded.
Okay, that's clear. To the NDPP, not to the DPP, according to advocate therefore.
Well, my lord, as I indicated, let the DPP make his own decision, and we can then take it from there, my lord.
He seems to be concerned about talk of the DPP and the NDPP.
Yes. My lord, Section 6B refers to the stopping of prosecutions, or of the prosecution, I'm sorry, and that's something, if anyone wants prosecution to be stopped, you have to give reasons, and the DPP then can consider that, my lord. And that decision of the DPP is in turn reviewable by the NDPP.
But that will be for proceedings that have already started.
Yes, that have already started, yes. There's the stopping of the proceedings that are underway.
There we are. I think, is there anything else?
None, my lord.
We have come to the end. I think the accused may rise. This case is postponed with the accused in custody to the 12th of July 2022 for purposes of argument around the issue of the second docket, as will have been ignited by the heads that shall be submitted by the parties in dates that were specified.
Icala ke liyahlehliswa langa 12 zikaJuly kule nyanga ke ezayo kuwona lo nyaka sikuwona. Isizathu ke sokuthi lihlehliselwe lelo langa ke nanjengoba kuye kwavela ke udaba lalo dokotela lesibili ke ila khona ke abameli bazofaka izithulo zabo kumalanga angaphambili kwalelanga 12 kaJuly. Nge-12 kaJuly bazokwethula ke noma baletha izethulo zabo enkantolo, so nizophinda nilethwe futhi nge-12 zikaJuly. Understood, my lord.
That's the court business.
At the court business.